What's going on, everybody? Good morning or good afternoon, where you are. I had some technical difficulties, as y'all can hear, trying to figure out what video was playing in the background, and we are waiting on Nick Brooks. So, in the meantime, I just emailed him the link again. Thank you guys so much for tuning in. Thank you guys so much for being patient with me. I appreciate all of you. Hopefully, you guys are having a happy Saturday. We're finally here. We're on Saturday. Thank God. Christmas is next week. So I'm excited. Thank you all so much for being patient. I was trying to figure out what is going on with that sound in the background. And turns out it was a meteor playing. And I was like, I can't believe this. So just for some housekeeping rules, we have the mods here in place. Um, we have a special guest coming on, Nick Brooks, who's an attorney. So if you guys have questions, please indicate your question with the question or Q in the front, and that way I'll see your question stand out. Also, if you just have commentary or anything you want to provide, um, that's fine. Just let us know if it is derogatory, defamatory, or disrespectful to the point where it's not. We don't have to tolerate disrespect. We just don't. Um, this is the one warning I'm providing. So if my mods have you timed out, understand this is the warning because I want the chat to flow and I want people to be able to have conversation and to feel comfortable. So, but the mods will time you out if they see something that is disrespectful or derogatory or defamatory. Respect the mods. If they say no all caps, please no all caps. And of course, Laura is the system admin for StreamYard. So she has a link where she could come backstage and get my attention a little faster. So if any of the mods are not able to reach me, and I'm, in the middle of showing a video or talking with Nick, just let Laura know. And she will hop on and be backstage and be able to message me backstage. So thank you so much, you guys, for tuning in. I'm excited. We're going to have a great conversation. Nicholas just showed up. I'm excited. So thank you so much. Make sure you guys hit the like button. Make sure you are subscribed to the Lady Luck Club. 63% of you are returning listeners, but not subscribers. So please, please, please make sure that you hit that subscribe button. We are growing here in the LLC, and I am looking forward to seeing 30,000 supporters. We're so close. We're so close. So make sure we are just like 42 people away from 30,000. So hit the subscribe button for me and show some love up in here. Thank you so much, you all, for watching. So what we're gonna do, I'm gonna bring on Nick. He can introduce himself to you all. I am excited, and let me make sure. I just have to have some noise in the background, just some mellow noise. And we're gonna get started with this. I am so excited. And we do have some videos we're gonna play. It's content. If I can get one of the mods to drop Nicholas Brooks' YouTube channel link in the chat, you guys make sure you go and support him. Okay. He has great content. We do have a video that is just general information about slap suits that I want to have him explain to you all so that you guys can have an understanding of the concepts of some of these various lawsuits that are uh, being filed and what they mean and what to expect when begin court proceedings. So general information he can provide to us will be very useful, I can guarantee you. So let's get going and let's bring up Nick. Good morning. Good
Good morning.
afternoon.
How are you? No, it's good morning for me. It's good afternoon for you.
Good morning. How are you?
No, very good this morning. I had, my coffee and stuff like that. So, I'm ready to go.
Awesome. Thank you so much for agreeing to do this. My apologies. I was having technical issues. So in the
No, I
beginning
was
of
getting
the
registered with StreamYard too. So that was an
yeah,
interesting process. I'm like, free
okay.
trial, I'll deal with it later.
Okay. Yeah, oh yeah. And when with StreamYard, I mean, I pretty much, this is my go-to. I don't use anything else. It's simple for me because I just don't have time to do a lot of editing. So it does have great features to allow you to be able to clip and do YouTube shorts and all those things automatically. So it can automatically generate, YouTube shorts for you if it's under, I think it's under 2 hours. So you don't have anything to worry about. I think your videos are
Okay.
like 4 or 5 minutes. So
Yeah, yeah, quick.
great content. Thank you so much. Attorney Nicholas Brooks is in the house, you guys. You guys say good morning to Nicholas. Attorney Nicholas Brooks. I am so excited to have this conversation with you. And of course, I think, been playing all of your videos you've been talking about with dealing with Candace Owens and the lawsuit and Turning Point USA. And of course, giving you the shout outs and the links. I have definitely been telling the Luxters and everyone to go and support you. You have great content. And of course, your information is always, highly valued because you are an attorney and you have the ability to give great insight without the biasness. I guess you're very impartial, which is a good thing, and that's something that people can appreciate. They're getting the information they need out of it without the fluff. You go right to it in your videos, and that's something that is, definitely unique. So why don't you introduce yourself to everyone listening? Tell us whatever you want us to know about you, and we'll get into a couple videos I have saved that I just kind of want to go through, and you can give us information along the way, and we take questions from the chat.
Yeah, no, first, thanks for your compliments. I very much appreciate that. It's been interesting trying to get my videos done, but your support, especially from you and Jay Witt and your followers, it definitely
Yes,
helps me to kind of like understand where to go. So, I appreciate that. And then,
no problem.
with respect to my background, I'm actually from Tennessee, Middle Tennessee. So I grew up in Columbia,
Oh,
Tennessee. But then I went to school actually at a small liberal arts university in Tennessee, Tennessee Tech, Cookeville,
okay.
Tennessee. Great university. After that, I went to
Hmm.
Rutgers Law School. We had the COVID pandemic when I was at Rutgers, so we had to leave campus. And
Oh,
then
okay.
to start my practice, I actually moved to Los Angeles. I had some friends there, passed the
Hmm.
bar eventually, and then started practicing. I've worked in primarily civil litigation in my career, so a lot of that just involves bringing claims, defenses, defending lawsuits, prosecuting lawsuits, and in
Hmm.
that process, you learn a lot about just identifying the relevant legal elements and then the relevant facts that need to be attached to those elements in order to like prove your case or disprove a case. So that's been a
Yes.
lot of my background up until now. I relocated to San Diego about a year and a half ago. And
Okay.
just recently, this year, I started running my own practice. So I'm actually kind of a solo, and I contract with a couple firms and stuff like that around the Southern
Okay.
California area.
Okay. Sounds good. Are you enjoying your adventures out there? Is it different? I would assume it's much different from being in Tennessee, right?
It definitely is. Like the one thing, I mean, it's a lot sunnier each day, and then a lot more dry
Hmm.
weather. Like we don't get a ton of rain, and
Okay.
it's rather irregular. But
Hmm.
in Tennessee, it was like you would get these storms that would pop up out of nowhere, and so
Wow.
it's definitely been different in like the weather sense. And then I would just say
Hmm.
like socially, there's a lot of similarities and stuff like that. I mean, I've lived in Jersey, Tennessee, Florida for a year, now
Okay.
California, so I've been around and like you can find good people everywhere, but I guess each place has its own little quirks to it.
Okay. So, if someone wanted to start their own law firm, what, I guess, good helpful tips you would provide to that person, and some encouragement that you would give to them
Yeah,
starting
no,
out?
great question. I would say if you're going to start your own, firm, definitely have an entrepreneurial spirit and like find it within yourself to like actually pursue that because it's a lot of unpaid hours. Like some of you
Mhm.
do billable work and then you do non-billable work, and so a lot of my
Mhm.
non-billable work, I'm not getting paid for all this YouTube stuff, kind of like Candace Owens' followers say I am. But so a lot of it's non-billable, and I getting out there, getting them kind of a how do I like an electronic presence, like people can find you online. You got to
Right.
take a lot of steps towards that. I manage my own website, so you
Mhm.
you have to do all that. And then I would say with respect to You know, I would work with other attorneys too. You know, find some good
Yeah.
attorneys you can get connected with. See if they can
Mhm.
give you some work. Maybe they need a little help on a case, and you can help them draft a motion or some
Mhm.
discovery or something like that. So, you know, you got to
Okay.
be networking as a professional, and that helps. And then whatever you can do to pay the bills, right? You know, that's the bottom
Right.
line for everything. So, and have goals for yourself. Like, you know, do you want to have a bigger practice? Do you want to be employing people? I mean, I'm not
Mhm.
necessarily at the point of employing people yet, but you know, hopefully, you know, my practice can grow to that point soon.
Okay. That is fantastic. And it is going to grow because you're getting a lot of traction here on YouTube. I don't know if you have any other social media. If you do, let us know and we
Yeah,
will make sure we send people. Okay. What do
I
you
got an
have?
Instagram, Nick Brooks esque. Please follow me. I try to post some
Okay.
stories. I need to post some more photos, but you know, YouTube's been an interesting like social media presence. I actually like it a lot, especially with the publication feature.
Oh, yes. So when you do your YouTube videos, then you can share and it can connect to your Instagram. So you can send your videos and when you go and share you know, if you want to go in your studio and actually share it, you can put your Instagram on your YouTube channel and then you can also share the content directly to Instagram. So it'll be a little bit easier.
Okay.
You know, when you're trying to because you can do videos on YouTube and I can't even remember my Instagram password. So
Yeah. It just
it's like
logs in
one more
automatically.
website. Yeah, once I get it reset, then I'll be able to do that. I just started back um going on Twitter X. And I have Twitter X and Instagram, and that's it. So it can be challenging trying to manage all three social media platforms. And I have a second channel on YouTube. So I do understand. That's why those little short cuts like that, where you can, hey, I did a video on YouTube. Let me just post it right over there on Instagram. And then, you know, if you have another website or your actual website, post a little snippet over there too. That
Yeah.
way it's easier, you know, and then you can also set that up like that in StreamYard. So if you want to stream to YouTube and then you want to connect and add Instagram, you can, and then you can of course always embed your actual URL for your website. And it'll
Hmm.
just kind of send it to automatically, it'll post it up over there. So it's just any little trick you can do to make it easier, save some time, and then still have great content on all three
Yeah.
is fantastic. So I want to get started with some videos that you have. I've been
Okay.
watching all of your Candace videos, but I do have one. And let's see here. We got two Candace, of course, that you've done. And then you have a video where you speak about anti-slap motions and protecting free speech, which I think would be definitely vital and helpful towards understanding some of the arguments that could be presented in the lawsuit with the Macrones. And of course, if anyone else decides to pursue legal action against Candace Owens, you know, a possible defense that they may claim, oh, this is a slap suit, yeah, Your Honor. This is attacking free speech. They're just trying to silence critics and those things that you can provide some information towards. So let me pull that up and we're pulling it straight from your channel. So hopefully you guys make sure you go over and support Nick Brooks' YouTube channel.
I'm Nick Brooks. Okay.
So I want to start with the newest one. I have not seen this one yet. Gave you a thumbs up.
No,
This
thank you.
is the Candace Owens Force A Medieval Medical Exam on Bridget McCrone. And this one right here is the one that I've been, you know, this topic I've been
Interested in.
screaming about for a while. Yes, because Candace Owens herself said, you know, I have my doctor fly out, get a little blood, get this done real quick because she knows she needs blood. In order to prove someone is born a man or a woman, you know, that's a matter of science and biology and human anatomy. Well, you need scientific evidence. And for her to have said that to me was an indication that she is aware that she needs scientific evidence. And so it's like she told on herself. So that's why I want to play this and then kind of talk through it and just kind of give us, you know, a breakdown if you can. And I'll take questions from the audience so people can learn throughout at the same time over the legal concepts that you speak on and they may not be fully aware of. So, uh, anything you want to add to this before we start? Anything else you want to
Yeah.
point out?
No, I think, you know, maybe this will be good, you know, going through some of the videos. I guess if there's any
Okay.
questions, you know, just you can feed them to me. I'll try to give like a short and
Yeah.
concise answer best I can. And then,
Okay.
yeah, with respect to those SLAP suits, I mean, really, SLAP stands for Strategic Lawsuit Against Public
Hmm.
Participation. And so, generally, if you're going to like identify when to bring a SLAP suit, you have to
Hmm.
identify that there's a like a public subject or a public figure that's being discussed, or like
Hmm.
there's what is it, petitioning activity. Now this, and then
Hmm.
I'm generally using a lot of California law terms. Each
Okay.
state kind of has their own SLAP litigation. It's a state law thing. So yeah,
Okay.
but yeah, that's generally what it is. Like here, we're dealing with Candace Owens. She's herself a public figure. She's talking about
Hmm.
Charlie Kirk, he was also a public figure. A lot of
Hmm.
these circumstances around allegations of his assassination are all public, public subject. It involves a criminal trial, potentially
Right.
with Tyler Robinson. So,
Right.
that's where, it gets kind of interesting with that. But we'll just kind of continue with the videos, and I'll see what I
Okay.
can do to answer your questions.
Okay. I have one highlighted, but I'll start doing some questions once we your videos are relatively quick, so I want to make sure we get that in and then we'll answer some questions. Okay. So if you guys can put a one in the chat once you can see and hear, let's get to it.
California attorney, and today we're asking whether Candace Owens can really force France's First Lady into what many people see as a medieval-style medical exam. The Macron sued Owens in Delaware over claims that Bridget was born male and part of a conspiracy. Owens says that she's coming for Bridget's medical records and pushing for an exam. The legal hinge is discovery, especially when courts will order invasive medical examinations in a defamation case about someone's body. Here's the setup. The Macrons filed a U.S. defamation suit, saying Owens launched a global humiliation campaign by insisting Bridget is secretly male and even related to Emmanuel. They say they sent her official records disproving that and that she kept going. Now they promise birth and civil status records, old photos, including pregnancy photos, and scientific expert evidence to show she's a woman. Owens is publicly talking about using discovery to dig into medical files and demand some kind of an independent exam. Legally, this all plays out in discovery, where both sides trade information and lock in testimony before trial. Owens wants every tool she can use to attack the Macrons' claim that her statements are flatly false. The Macrons want to prove falsity without turning Bridget's body into courtroom entertainment. So we'll walk through what normal discovery looks like in a defamation case, what extra showing courts usually demand before forcing a medical examination, and why using someone's genitals as evidence feels to many people basically medieval. In American civil cases, discovery is broad, but not limitless. Parties can send written questions, demand documents, issue subpoenas, and take depositions on anything reasonably tied to the claims and defenses. Court-ordered medical examinations are different. Judges treat them as serious intrusion into privacy and dignity, so they typically insist that a person's physical condition is a central issue and that there's a strong reason to invade their body. The default is get what you need from the records, testimony, and experts first, and only then even consider a medical examination. Even without a medical examination, Owens has a lot of discovery firepower. She can serve written questions, forcing the Macrons to identify every document and expert they'll use to prove Bridget's sex and family history. She can request civil status records, school and employment files, prior French decisions on these rumors, and the photographic and scientific evidence they've promised. Then she can depose the Macrons and their experts, pressing on gaps or inconsistencies, and subpoena French officials or prior litigants who investigated the same conspiracy. That's aggressive, but still standard modern discovery. Now, the controversial part, a court ordered medical examination. Owens has been portrayed as coming for Bridget's medical records and demanding an invasive exam to prove she wasn't born in a man. From a dignity standpoint, many people see that as medieval, turning a 72-year-old woman's genitals into evidence to satisfy an influencer's conspiracy. Modern judges know forced.
Can I pause here?
Mhm.
Say, okay, so I want to pause here for a moment because, you know, the Macrons, of course, have said they're going to bring in scientific evidence, but it is egregious to think that she is entitled to this type of discovery. So explain what limitations she would have regarding anything regarding medical records, regarding any medical test requested, you know. And do you
Yeah.
think she would even accept the results? I mean, Candace hasn't accepted all of the exhibits they've sent to her so far. Do you even think it would be worthwhile and she would accept the results?
Yeah, so the case is proceeding in Delaware state court. So Delaware
Mhm.
Discovery rules are going to apply. Those are civil procedural rules. And so Candace
Mhm.
Owens, generally in most civil procedural rules in all states, you can receive like requests for production of documents, so she can get certain documents, but they have to be sufficiently related, in fact, to the
Mhm.
case. She can't just go on a fishing expedition. Any
Right.
attorney would object and say, objection, irrelevant evidence, objection, privacy. And so there are
Mhm.
limitations in that aspect that the parties can definitely argue. And I think the Macron's attorneys are definitely going to have to object to that, because I can imagine
Right.
Candace Owens, attorneys are going to seek as much medical documentation as they can get, and they're just going to leave it up to the other attorneys to object and see if they assert the objections, and if they want to actually take that
Mhm.
issue in front of the judge. Because once you take a discovery issue in front of the judge, there's a potential you could be sanctioned for it on each side. So generally, the parties don't want to have these types of discovery issues appear in front of the judge.
Right.
With respect to, she can get requests for admission. So Candace Owens could ask, admit that you were born a male. And if she denies it, Bridget Macron denies it, well, Candace Owens, if she's later able to prove this is true, she can actually recover her attorney's fees for it generally. We got to check the Delaware statutes on that to verify. Um,
Mhm.
so yeah, she's got requests for admissions that she could potentially ask, admit that you have certain chromosomes, for example. She can ask just
Okay.
general interrogatories. She can say, state all evidence that supports your assertion that you are not born a male. And then we'd see how in writing, Bridget Macron and her lawyers would respond to a question like that. And so,
Mhm.
Candace Owens has a lot of discovery firepower in that sense. Now, the issue
Right.
arises, and this is what I started to kind of just think up one day, where you can order generally a physical examination of somebody. So let's say somebody's
Mhm.
claiming that their shoulder hurts after a car accident or something like that. Well, let's
Right.
go ahead, and their shoulder issues at issue, and let's order a physical examination of that.
Right.
It's and then it's usually going to be an independent medical examiner who's going to provide that
Right.
and provide an independent evaluation. They're getting paid regardless. They don't have an interest in the case. And
Right.
so here I was thinking, I was like, well, if Candace, and you have to move for a physical examination, you can also move for a mental
Mhm.
examination. But when you move for it, that means bringing a motion. You generally have to
Right.
show good cause, and so
Right.
that's to me going to be a bit of a burden, because you're essentially trying to say, hey, I would like to force a physical examination, and then when you're trying to state the good cause, you're going to have to address the fact that the
Mhm.
documents, the maybe testimony, the other
Right.
types of discovery were insufficient to prove what you were trying to
Right.
prove. And a physical
Right.
examination generally does involve like the physical examination, like as
Yeah.
much as it's going to like involve, is it going to pull the person's pants down, like that's kind of what I was getting at. I was like, that's a little bit far.
Right.
And then, I see a lot of people in the comments talking about a DNA test. Here, I'll have to do some more kind of research on that and generally how that's treated. But if somebody's going to like prick your finger, I've not really heard of that. I've heard of criminal cases or family law
Your
cases.
blood.
There's DNA
Mhm.
evidence that's used to either establish paternity or
Mhm.
establish criminal liability and things of that nature. But in a
Right.
case like this, to actually like submit somebody to a DNA test, that's an interesting one. I've not heard of like a ton of cases like this in the first place. And so,
Right.
you know,
Me
and it
either.
wouldn't have to be a pricked finger. I guess you could swab her cheek or something like that and, maybe
Mhm.
satisfy it. But also too, it's like, do you have to swab the cheek if you're able to just get certain medical documents from, let's say, like her childhood or something like that, that
Mhm.
shows that she was a woman in her childhood or something. And it seems like right now Candace Owens has put on her podcast that it seems like there's a lack of evidence related to like photographs or medical documents or something. And so that's what they try to argue is like, because there's a lack of evidence, that means that, and that's not always true, but I
Yeah,
guess you
it's
can't.
certainly not true from
It's
her.
tough to eliminate, right?
Right. It's not true from her because she's received, a birth announcement, photographs, just answered, statements. They've, tried to provide her as much information. That the information she's received is also outlined in the um First Amendment complaint. So there, exhibits that they sent to her, they're also using for the lawsuit, but she hasn't accepted it. She's basically found some excuse with it. Either the photos are proctored, she doesn't know if they're valid or real, and you know, Candace has no way to vet tips coming from her tip line. So for her to think that, she has the ability to say whether a photo is valid or not is absolutely irrelevant with court. They're not going to care if she can validate it. The Macrones would have to be the ones to provide that valid, legitimate, exhibit with photos, ensuring that it's not cropped. If they want to make the argument, they can, which they probably will. But you're basing it off of what? Because then that will have to show that they have some way to validate these photos. And Candace is not an expert at validating anything. And then of course the blood, or even just DNA. The judge more than likely is not going to order, and you can correct me if I'm wrong, it's not going to order Brigitte Macron to take a blood test or to do any diagnostic testing. But if they bring in their own evidence that they want to admit into the case, that is a diagnostic testing. Um, and they're giving this information to the court and to the other party. What is the likelihood of that being admitted? If they bring it, would the judge see that as appropriate?
Can you ask your question again? What was it?
The DNA evidence, if the Macrons bring in diagnostic testing that they want to admit to the case, would the judge permit that to be admitted without without any
Generally
issues?
speaking, and this, again, it's all going to be under Delaware law, but generally speaking, obviously you would have to authenticate the evidence that it's true and
Right.
purports what it says to be, which is the DNA of, I suppose, Bridget Macron in this situation. And so like, you're going to have to get authentication, and then likely you're going to have to get experts to support that, this
Right.
DNA test is accurate and is supported
Right.
by scientific, standards. And so there's going to be expert testimony. I'm sure Candace would find her expert that would say one thing. The other side's going to find their expert. And ultimately, a lot of this is going to come down to findings of fact. Is this
Right.
document true? That's not always a question of law. That's going to be a question of fact. And where that's
Right.
a question of fact, those questions of fact are always submitted to the jury. So it's going to be up to ultimately a jury, if that's what the parties choose to do as a jury trial, and people will decide,
Yes.
are these documents true? And so yeah, that'll be up to how many jurors are going to be in trial for that, is how I would see the findings of fact in a lot of this case.
Okay. I do have a couple questions here that I want to ask quickly. So this is from Snapple Apple. Nick, can the Macrons add Candace publicly accusing them of an assassination plot be added to the current defamation lawsuit?
Yes, I do believe that they could add that, by
Okay.
filing an amendment in order to get that in. I guess it's just the question of this: how complex do you want to make this case? And
Right.
I do believe, generally defamation per se is accusing. That's just where, when you say something about a person, it presumes reputational harm. If you accuse somebody of serious criminal activity, that, such as an assassination plot, that's going to be serious criminal activity that presumes reputational damage. So I do believe that they could add that. It's just then the issue becomes, once you're arguing this later at trial, you have to not only address the gender part, now you've got to address the criminal activity part. And do you want to risk confusing the jurors? Because these, jurors don't practice law every day, and they're not holding these legal issues in their heads. And so sometimes it can blend and get confusing. And so, maybe the attorneys, before they amend their complaint, they really want to see, like, do we want to just focus on one issue, try to win on that, and then maybe pursue the other, assassination plot allegations independently. And so that's kind of how I'd frame that.
Okay. Let's see here. And that's a really good question. Thank you. Snapple Apple. Shout out to Jay Witt. He is in the house. My brother in Christ. He sent a $10 super. Thank you so much for the $10 super. Where is Nick from? I'm getting some Southern vibes.
Thanks to Jay Witt. I get a lot of green hearts in my comments. And so when I see those, I think of him.
All right.
But yeah, I think I'm actually from Columbia, Tennessee, which that's Middle Tennessee, about an hour south of Nashville. I was born
Yeah.
and raised there, and then I went to Cookeville, and I actually worked for my university's football team, like on the coaching staff. So we had a couple games down in Georgia. We had to play like Kennesaw State, Mercer.
Oh.
Yeah, so we and like before I got there, they once played Georgia. They got destroyed, but we've definitely been down to Georgia.
Okay. And he had another question. So what if Brigitte Macron is a hermaphrodite? What if she have both
I don't
parts?
know what the definition of a hermaphrodite is. Truthfully,
being
I've heard
born
that
with
term for. Well, go ahead.
Yeah, it's being born with both reproductive organs.
Yeah, I don't know. To me, like that just kind of I don't really have a lot of information on that. I've never really heard of that. In my own experience, so it'd be tough for me to comment on that.
Okay. I mean, if I guess he was asking if she's born with both reproductive organs, you know, I guess that would that prove I mean, for Candace to be right and Brigitte Macron to be right. She says, "I wasn't born a man or woman. I was born with both parts." But
yeah, it's kind of interesting. It's like I mean, in some ways, I guess formalistically speaking, it's like you're kind of right and wrong, whatever you accuse, right?
Right. It was like both parties will actually have a valid point.
Yeah.
He wants to be tapped in. I'm gonna drop the link as well, so we can hold on 1 second. And Jay Witt is one of my mods here. Is in the Lady Luck Club. So that is for you, Jay Witt. Come on up. Let's get through the rest of this video, and then there's 2 more. And in the meantime, I'll bring Jay Witt up onto the stage while this plays. Thank you.
Examinations are an extraordinary intrusion, not a routine tool. When a plaintiff already offers pregnancy photos, official records, and scientific experts, courts will ask what real justification exists for dragging her into a stranger's examination room instead of relying on those documents and expert review. Big picture, this case hits a fault line between aggressive free speech defense and basic human dignity. If courts normalized using defamation suits to demand invasive medical examinations of public figures' bodies, the choice would be this: live with viral lies or submit to something that feels centuries out of date. Instead, the system tries to stay modern. Let defendants test truth with records, testimony, and experts, but keep a high bar for touching anyone's body. For creators, the lesson is simple. If your content accuses people of hidden anatomy or secret identities, you're betting you can defend those claims against real evidence, not that you get to set a stage for a medieval-style medical examination. If you found this helpful, hit like so more people see it. Before you go, tell me in the comments, should courts ever force a public figure into an invasive medical exam to prove defamation wrong, or is that a medieval line that we should not even cross? If someone follows Candace Owens or works in the media and politics, send this to them so they can see where the legal line really is. And if you want more breakdowns like this from a California attorney, subscribe and turn on notifications so you don't miss the next episode. Thank you.
Okay, so Jay Witt
in the building. What's happening? Hey, how are you, Lady Luck? What's happening, Nick?
Hey, nice to meet you, Jay Witt. I
Very nice to
appreciate
meet you.
your support and followers.
No, I appreciate your content, my sir. You've been doing an excellent job. So don't worry about it. The invitation is being extended out to you. This is basically my way of bogarting my way in to get you to come on over to the Jay Witt podcast. But the term the term hermaphrodite has been upgraded. It's now called intersex. So it's a person who is born with, whether it be both body parts or they could have an extra chromosome, both genital parts or extra chromosome and it's such like that. And if you ever do like a deep dive into it, it's kind of sad because these people, they're not trying to be difficult, but it might be a woman that has just like a lot of extra muscle mass, or a guy that just is extremely thin and frail. And it's not because he's trying to be anything like that, but it's just because of their chemical makeup. And I'm just wondering, looking at, Brigitte Macron, not judging, not saying anything. I said, what if the whole issue is that she's intersex and she's been trying to keep it a secret, and this woman is trying to drag her out there. She's at the latter part of her life, and she's gonna have to let everybody know, by the way, I have, I was born with extra chromosome or whatever like that. That's why I asked the question about being hermaphrodite.
Yeah, I mean, ultimately, I think potentially there's medical documents out there that are
Mhm.
relevant that would show that, and Candace Owens would have a right to those medical records because it's relevant to her case. And ultimately, the Macrones brought the case, so they put it at issue as well. So they're going to have to submit to that, and if they don't submit to that, well, the Macrones' case could be dismissed. In that sense. So I do believe that if that medical documentation's out there, they would have to produce that, and that would be very conclusive to me on a lot of those issues.
Mhm.
But again, I think right now, I mean, I would just say maybe Candace Owens' lawyers can craft a request for production of document like that. But it's a little speculative, from my sense, because I don't know a lot of information outside of that other than how you would frame the question for the party.
No, I got you. I did drop the link. That's what I put in there, Lady Luck. If anybody's
There you
interested, I just put a
I
quick
started.
little link about the whole intersex thing. Because I was just thinking, like, what if, again, I ran across an athlete who was intersex. She was telling her story, and I was like, man, her story was really sad to hear. All the stuff she had to do in order to have children and all that kind of stuff like that. And I was like, what if Brigitte? What if this is Brigitte's story again? Not justifying Brigitte, but I'm just like, man, what if this was her story? What if like she was intersex and she didn't want anybody to know about it? And
Well, but
go ahead.
I was gonna say, we have to remember that, Brigitte had 3 children, and
Mhm.
the DNA test can be done on her 3 children to determine that those are her kids as well. So medical
Yeah,
records
and if there's a
from her
connection, I
giving
would.
birth. Yeah, I mean,
Right.
you can't, if you're a hermaphrodite, I don't think you're able to have children. So
The one that I saw, she did, but
she did. Okay.
it was very troubling for her to do it.
Okay.
But
Yeah,
I don't want
Brigitte
to get into a
Macron
woman's
had
business like
3.
that.
Yeah,
Right.
exactly.
So three would be a
3.
lot. 3 would be a
and
lot. I mean,
and the
everyone I've
thing,
seen has only had one.
right. And it's just too, she wanted to provide medical records, that speaks directly to her womanhood. I think she would provide, OBGYN related records because she's going to have a physical exam that's going to include, you know, um, looking at her reproductive organ. So if it goes directly to, her genitalia and
Right. Yeah.
what's down there and what's going on. So those will be specific medical records that can be utilized if Brigitte Macron wants to bring them. She's bringing scientific evidence. I'm just curious to know what it is.
Mhm.
But when it comes down to an exam, this is why I personally said I don't think that the judge is going to order one if they're willing to bring in scientific evidence that will directly prove that she was born a woman. So
No
I
argument for
don't
me.
know what Candace says random things, and I don't believe anything she says at this point. So
Right.
And
Can
she just
and
puts
go
things
ahead,
out
Nick.
there. Go
Well, I
ahead.
know, like, too, one of the issues in this case is like, since it's defamation of a public figure, there's also the actual malice standard. So if we're
Mhm.
defaming private figures, like people that have no publicity, a negligent standard is used. So if you say something casually that's defamatory, even if it's negligent, you could be held liable if it brings reputational harm. It's just the issue becomes when the plaintiff's a public figure, such as a politician, maybe a big business owner, or even I would say like for you two, you are you do a lot of commentary on this and get followers. So I would
Mhm.
argue that you're limited public figures to some extent, and so on this issue, you people could hold you to an actual malice standard like you would if you brought it
Mhm.
something. But that's not me providing legal advice for the authorities out there.
Oh yeah,
But
we
like
got you.
when it comes to the actual malice standard, that is a requirement that came out of a case called New York Times v. Sullivan. And I don't know if,
Mhm.
if you two are actually familiar with that case, but New York Times v. Sullivan was it involved like a 1960s ad that was run by a
Mhm.
bunch of Martin Luther King Jr. supporters that
Mhm.
accused the
Right.
Montgomery Police Department of criminal activity such as like the
Right.
bombing of MLK's home,
Oh
involved
wow.
in the
Right.
political suppression of his followers and through criminal arrests and things of that nature. Now they
Right.
didn't say Sullivan by name. What they did is they said the police in Montgomery. And since he was the
Right.
police commissioner, he argued that defamed him. And
Him.
Right.
Right.
so there was a jury, and it was an all-white jury actually in Alabama that awarded
Mhm.
$500,000 to the sheriff or the Sullivan for that. And so that political group appealed that decision all the way to the Supreme Court. And so that's how we got New York Times v. Sullivan, because they ran the ad in the New York Times, and then the New York Times, since they're a big media company, they had the deep pockets to pay a judgment like that, or so the Montgomery police thought. And so they sued them. And, while they were successful at the trial level, they were not successful at the Supreme Court. And the Supreme Court, that's where they held the actual malice standard. And that actual malice just requires, you have knowledge of the falsity you're spreading, or you have reckless disregard for the truth. And so what I believe that a lot of the Macron's lawyers, and maybe even Erica Kirk's lawyers in situations like this, first, what they want to do to establish evidence is send notices of that's wrong, notices of I'm not a man, or notice of, this is defamatory towards this person, you name it. And so what that's supposed to do is impart knowledge on the speaker that they're that the facts they're stating are wrong, or they're stating it with reckless disregard for the truth because they've already been provided evidence for that. And so I think that's a lot of why we're hearing about these meetings, them sending documents, and it's all public that way to establish maybe some public support where this later becomes an issue on, did Candace Owens or any other speaker for that matter have knowledge of a falsity at the time they stated it, or just reckless disregard for the truth of what they were stating.
Right.
No, I got you. No, that makes perfect sense. Go ahead, Lady Luck. I'm sorry.
Oh, no, I was going to read a question here that we have from
Put all three of us on the screen. Put all three of us on the screen, because I can't see
me?
I can't see myself. There we go. Now I'm back.
I have a video. We're going to go back to it. The second video, we have 2 more videos we're going to play.
For sure.
And he's just kind of talking through it. So here is Heather Rose. Thank you for the $4.99 super. Jay Witt, make sure you go stream it to your channel as well if you want.
Okay.
Can Nick read through the complaint, explaining each section and is that item as he goes?
Yeah.
Nick, are you able to, break down
I'll say this. I've already looked at it. It's a really long complaint. And I think trying to go through each section might be difficult, because when you're dealing with these really public cases like this, the attorneys have an incentive to kind of be really superfluous and, wordy. And so trying to go through section by section, ultimately, a lot of the things they say might not have relevance to the case. It just paints a good narrative to me, and, kind of get some headlines and people read it and get sympathetic to the Macrons. But trying to go through section by section, it might not be the most productive aspect. But I would just encourage, you can Google, for example, Macron v. Owens PDF, and you'll stumble upon it, because, there's a law firm out there is how I accessed it. And I think the actual, the first, you have it?
I'll have it. Lady Luck, I'll send it to you in a second.
If you want to pop it up here, we can go over maybe the introduction or something like that, and maybe just kind of go over the structure of it. And I could show you maybe how I would kind of quickly read it. But, I think it's over 150 paragraphs. So that's a lot of paragraphs to cover.
Yeah, it is. It's very lengthy. Even when I went over it, I had to do a summarizer on it, just to kind of get the bulk of the information out. Hold on, Jay Witt just dropped. Let me make sure. He just fell off. I don't know what happened. I'll just let him know he can come back when he get a moment. Okay, here we go. What happened to you?
Here we are.
Rookie, straight up rookie, a rookie. I'm over here and I'm talking to myself. I'm having a good old conversation. I'm like, why is nobody saying anything? And it's gone. So anyway, I was saying before, take your hands off the mouse, Jason. I have the amended complaint as well as the original complaint in a file. I'm gonna drop it in the private chat for you, Lady Luck. I think you have it already. You have access to it. It's just a Google Doc, and every time they add a new file, every time they do something, Nick, I just keep it updated so people can follow along with it. And you're welcome to have it if it matters. I do want to ask,
if you would like to, Jay Witt. I was explaining while you were gone. If you want to maybe touch on it, we can go over maybe an outline of it and kind of quickly bounce through it if you like. But it's like 150 paragraphs, so it's a lot.
It's a lot. It's a lot. It's abusive. And I think the last thing I heard you saying, which I think was very important, was that lawyers are not they're not They're not held to any kind of brevity. They don't have to be short. They can be as long-winded as they need to. They can even ask for extra time, extra pages, extra words, because that's what they did.
Yeah.
They were
Now,
seeing. I think that was a tactic for them to try to, I think they're stalling.
no,
I don't know
right,
why
because
they keep asking for extensions.
it's
on
going to take you a whole
words.
month to read the dumb thing. I mean, it's crazy. But I do appreciate, Nick, that you answered a question actually that I had, which is because I personally thought that the Macrons would have slapped another 50 pages onto this complaint because of the whole French put a hit out on me, which
Wow.
I don't believe that actually happened. But
And
I got my maroon shirt over here just in case. And I got my maroon shirt because it's the maroon guys that are the killers. But I
buckets of
was like,
maroon
well, why
beret.
did they not amend the complaint? I just knew they were going to amend the complaint. I said, they're going to kick, because it's already at 250. I said, they're going to kick that foolishness up to 300 pages easily. And they never did. But you did say something, how complicated do they want this to be? And maybe
Right.
that's why they haven't done it. Because I really thought, I'm just sitting there chomping at the bit, like they're going to add 50 more pages. They're going to add more. And it never happened. I'm a little bit
It is-
And they
disappointed.
could maybe recover on it independently, right? Like why
Right.
amend the complaint? Why not just maybe? I think they would have the right. Obviously, I'm not a Delaware attorney, and I have to check the civil procedure rules. You could bring that in another docket, so you
you
maybe
can.
you still have that right, and so like they could
Wow.
bring in another case.
Mhm.
And ultimately, I think cases like this would typically settle. But I mean, it could go to trial. You never know, and so maybe they could involve that in like a settlement of some sort.
Gotcha.
And I did say that that Candace, if she has her motion to dismiss denied, more than likely the next step would be for her to try to, because she's never going to admit it, but her attorneys are going to try to get her to mediate and settle out of court because
Oh, yeah.
they don't want this to go through. There is a jury demand, so they
Yep.
don't want this to go before a jury, and they definitely do not want their client to get on the stand and be deposed at all because she's a pathological liar. You don't
Well,
put
let me-
pathological liars under oath on and get deposed. So
Let me
they're trying to avoid her from answering questions.
let me also add another piece to it. She'd have to be in court every day.
Yeah.
So that would
She don't
ruin
wanna go to
her
court.
show. That would ruin her show.
Oh yeah. She's
'cause I
got
would-
a homeschool.
Yeah, she's got a homeschool. She does her show allegedly. It's live at 4:00 Central Time. I would make sure that this case went to 7:00 every night. I would just ruin it every day, Monday through Friday, 7:00 every night.
Yeah.
It just
She would miss a week of court, week of shows.
easily. Oh no,
It's just-
we're gonna miss months
be
because
so
I'm gonna
many-
drag this thing out. I'm calling Sunday school teachers, mailman, the guy that changes your oil in your car. I'm asking people who don't even relate to it. Hey, I saw that guy walking down the street. I need you as a witness. I'm calling everybody. I'm just dragging this out. I'm calling Woody from the YSL trial. He's gonna be up in there. Everybody's gonna be up in there. Nick, you're gonna get a deposition. Whoever did that lion poster. By the way, my audience really loves that painting. I don't know who did that, but watch out because that person's getting deposed too. Everybody.
Hey,
Right.
Jay, I only thing I'm gonna say is these legal bills are
You-
running up with each person you state. So I'm like, wow, I'm gonna get a payday as an attorney on this one.
But
Oh,
for
her
real,
3 attorneys are gonna get paid. All right, they're getting paid. She probably is mad and having to do all this nonsense to pay these attorneys because
so
it's gonna cost. So,
oh, no question about that. So Nick,
Yeah.
in your professional understanding, like as it relates to the Macron case specifically, could you give us like an idea, just like a pre-K law student understanding of what in the world is Candace doing? Like, what is her end game? Does she really think she's going to win this? Or, I mean, I appreciate you giving like some fair, like there's a possibility, but let's just say that Macron's really is Brigitte is really a woman through and through, no intersex or anything else of that nature.
Mhm.
Candace is gonna lose heartily. What does she think she's gonna do? Like, what is her strategy? If you can maybe look into the crystal ball
or
and say
speak
this is
to
probably what she's
intent,
doing.
maybe. Her
Yeah, intent.
Yeah,
That's the
on
word I'm
this.
looking for.
Yeah.
Yeah, I mean, with respect to like, maybe an end game with this, obviously, there's been a lot of attention that's been, gained from spreading, these types of, statements and stuff like that. So I think she's definitely been able to monetize on it. She crafted that Build and Bridget series.
Mhm.
I think it Oh, I think we lost Jay Witt
Yeah,
again.
he says again.
Yeah. Yeah, I mean,
Well,
I guess I can continue on, but I mean,
yeah,
with
go ahead.
respect to like an end game, she thinks that she can. Oh, here he is. Yeah, and
Okay.
Jay, what I'll just jump back on. I mean, with respect to an end game, obviously the Macrons think they can prove their allegations, and now one of the elements of defamation, because defamation generally in all American states, it's a defamatory statement of fact involving another
Mhm.
published to more than a third party. And there's no applicable defenses, and it causes reputational harm. Now, if
Right.
Candace Owens is able to prove truth, that's a defense. And by showing truth of her, like she is a man, well, that would, ultimately be a way to negate one of the elements required to prove defamation in this case. So Candace Owens has to argue truth. And the only way she can prove her claims related to truth is she needs sufficient evidence to do that. And so that's why she's going to have a right to see if she can get, certain documents and, maybe testimony and things of that nature. But, that's the thing is I think for her side right now, they're going to argue that they don't see it as so clear cut and that there still needs to be evidence to be had. And then ultimately, too, I learned from a professor in law school that all stages of litigation are really tools of settlement. And so, if she does lose this motion to dismiss, well, obviously, then the case would proceed into discovery, and both sides have the right to discovery. And so the Macrons can gather information related to the financial gains had from this, her communications with others involving this. And so, like, depends. Sometimes you can't get tax information through like privacy laws. It has to be sufficiently relevant. But it could, depending on the circumstance. So that's what, I would think is just both sides are trying to gather evidence and prove their claims. And I don't think Candace Owens wants to see discovery in this because that's going to be really somewhat invasive. And who wants to start going through their text messages and emails to try to collect all the communications they've had involving Bridget Macron? And maybe there's a lot of them. And, who's to know what they say, such as, they could say anything.
Right, exactly. I have a question up here from Care Bears. Shout out to you. Thank you for the $4.99 super. What do you think damages are worth? Over 50 mil?
Oh, that's a good question. Generally when we're dealing with like defamation, you got to prove financial losses or potential financial losses and stuff. So if you guys recall, there was the Johnny Depp Amber Heard defamation trial. And Johnny Depp was awarded a $10 million judgment, if I recall, based on that. And that occurred here in California. And, so one of the things that was a challenge for his case, and it's a challenge in all defamation cases, is how do you calculate financial losses where you haven't signed contracts yet? What are the Macrons going to do? Like, are they saying that they've lost out on business opportunities? That's going to be difficult because they are politicians in some sense. So like that may be a bit of an issue to kind of run into. Could they recover on punitive? Maybe that's going to be governed by, state. I mean, you generally for punitive damages, you have to prove malice, and that's a little bit different from the actual malice standard of defamation, even though the terms are similar. So it's very complex.
Okay. And
I was just going to ask, how about like if, family and Lady Luck has defamed me and it's been adverse to my own family and such like that. Can that somehow or another be calculated? How do you calculate that in? Because all of her children have,
children are being harassed and they're being bullied online. I think I read where grandchildren were also being
even grandchildren,
grandchildren are being bullied as well. So
in a situation like that, I think that the individuals that are facing that, like bullying or harassment and things of that nature, they would have to sue themselves under the proper theories of harassment, whether those are common law theories or statutory theories. Yeah, and so I think if they're going to argue that they're personally suffering, I would say that these individuals are going to have to bring their own claims. Those claims wouldn't necessarily attach to the defamation claims brought by the Macrons. Because ultimately, you're trying to, when you bring something to court, you're trying to recover for the injuries that you've suffered, not that other people have suffered, unless it's like class or representative, which we don't have here.
Could their concerns, though, be used to help to show more context to the extent of the damage that's being done as it's extending out to her, immediate family. Could
Yeah,
that
and
could
now
it be
that's a
used in that way?
now that's a different point in some sense, and it's a good point. So for purposes of
Mhm.
like evidence law, it's possible that, where you want to show that there's been reputational harm, let's bring,
Mhm.
certain family members that have suffered bullying or harassment, as a
Mhm.
result of reputational loss. And so
For sure.
potentially that could be used as evidence on how
Okay.
it's framed, or, if it passes certain evidentiary standards. So I think, yeah, that could be one lane of getting that type of evidence into court, but it might be for
Mhm.
for a limited purpose of showing certain reputational loss.
Okay. And I do believe her
Got you.
brother will be present to testify.
Yeah.
He's not a party to the case, but he will be testifying as a witness, I believe. So that I think because they have the appeal still ongoing in France with the two
Hmm.
journalists. So
And the
it's
10,
just
the
so
10,
many similarities of this.
and
It's
there's
just
the
so crazy.
10 vloggers too.
Oh wow. Okay.
Yeah, the Macrons are suing 10. They were suing 10, basically, content creators or people commenting online for
Hmm.
this exact same thing. It started early in November, and it's already over, and they're waiting for the final verdict to come back. But there's 10,
Okay.
again, it's just the same thing. They were calling her a man, so on and so forth, carrying forth this rumor and whatnot, and they got sued
Wow.
for it. And matter of fact, Amadi Roy, who was initially sued by the Macrons, she's in the case too. So
Oh wow.
they believe in suing folk. The French do
Yeah.
believe in suing them.
And Nick, I guess it'd be a great time to ask that question. Do you think that the Macrons should have sued Candace Owens in the first place?
No, it's a good question.
Hmm.
Hmm.
I think it really comes down to how each party feels about their own case and circumstance. What
Hmm.
do the Macrons feel they have to lose in a situation like this if they don't
Hmm.
check Candace Owens, for conduct or, statements they don't like? Do they
Hmm.
feel like they're doing this on behalf of other plaintiffs? I'm not so sure that's the case, but, is there a
Hmm.
consideration like that? So I think it just comes down to, what does each party want to recover? But generally, if you suffer reputational losses, like somebody accuses you of criminal conduct, also too, professional malpractice. So if you accuse
Hmm.
another of, you stole from your business or something like that, that could be presumptively harmful to a person's reputation. And we could calculate damages from there. Now, I guess something
Hmm.
that kind of crossed my mind just now is, there's defamation per se, and defamation per se is where you say
Right.
certain statements that are presumptively harmful to a person's reputation. You do not have to
Right.
prove any specific financial loss. You can just say, they said this. I'm not proving financial loss. It's harmful. Now, there's a couple
Hmm.
categories for defamation per se, and they vary on the different states. But it generally
Okay.
comes down to, being accused of serious criminal misconduct,
Right.
professional, non-compliance or professional misconduct, uh, historically unchastity of a woman, interestingly enough. But I've not heard, accusing someone of being another gender. So that's
Right.
gonna, I don't know if it's gonna cleanly fall under defamation per se. And so I don't know if they're gonna be presumptively entitled to reputational harm. They may actually have to prove specific financial loss, the Macrons. And so that's
Hmm.
where I was questioning earlier. Well, what will they show for that? It's not so clear to me at this point.
Right.
But they'll gather that information in discovery. Candace Owens can ask an interrogatory and state all facts in support of your claim of financial loss, for an example, and then we could learn.
Right.
So
Go ahead,
then,
David.
okay, so let's jump to Alex Jones. What was the loss besides Alex Jones was sued for $1 billion. I mean, that was crazy. But how did they calculate that then?
Was that primarily on emotional distress with that Alex
I'm
Jones
emotionally
lawsuit?
Yeah, that's
distressed
an
by the
interesting
thought of it.
question. Was it defamation or was it intentional infliction of emotional distress? As I discussed with you, I haven't
Ah,
reviewed the facts prior, so I'd have to kind of catch
Hmm.
myself up on that. But it's an
Okay.
interesting point, yeah, because if it's intentional infliction of emotional distress on the parents, for example,
Hmm.
then
I
that's
think
why maybe the jury could have said, we found that to be an acceptable theory to hold accountable him. And then when they're
Right.
imposing damages, they would be entitled to impose punitive damages because it's a tort. and if it involves malicious activity. And so then that's when maybe they could impose something like $1 billion just to send a message. Now that's just me kind of like coming up with a theory right now. I'd have to run that theory through actually what occurred in that case.
Yeah,
I'm trying to look it up real quick, but yeah, go ahead with the question about the camera.
The camera, yes. From Wyoming gal, shout out to my mods. Can any of this be done in camera with court? Like, can the camera, the media be allowed? I know that this can be open to the public, but can media be allowed in this particular court hearing to live stream?
Yeah, so two things. I would say it can definitely be live streamed if it's approved by the judge. And, and I'm sure like maybe Candace Owens' side would oppose that. But, we don't know exactly what they would want to do because maybe they have an interest in having something like this on, on media. And then with respect to in camera, I know that like historically that means like in chambers. It's an old Latin expression. And so if that's what the commenter meant in the in camera, like, in the chambers of the judge, resolve it. Not necessarily, like that's why we see these public filings. Obviously, each side's filed there's been a complaint filed. There's been an answer or motion to dismiss, filed by, Candace Owens and then an opposition. So none of that is in camera. They're, obviously the judge is going to consider that. He's got to read the papers and then draft an order to that effect. That's not necessarily in camera. In camera just means like, the party's attorneys are meeting with the judge in chambers to kind of resolve stuff. And that doesn't generally occur in civil litigation.
Okay.
Gotcha. Can I real quick say what Alex Jones was sued for? Now, again, I went to my legal, I'm a pre-K law student, Nick. That means I know nothing. So I went to Chat GPT and just asked what was he sued for and what was he found guilty for. Okay, so real quick, Alex Jones, the family sued for defamation, intentional infliction of emotional distress, and civil conspiracy in some claims. What was he found guilty? He was found liable by default for defamation in both states because he repeatedly refused to comply with the court orders, failed to turn over evidence, and was obstructed in discovery. And then what the court concluded that Jones' statements were false. He knew he knew or should have known they were false. His actions caused severe emotional harm, and his platform amplified harassment and threats against the families. Damages.
Wow.
Texas, about $49 million, later reduced by the state to the state cap. Connecticut, about $1.4 billion, including punitive damages. All right.
Wow.
So, I mean, there's a little bit more, but that's the summary of it. I don't know.
A lot of this seems to have come from.
Because ultimately you stated two theories. There's a defamation theory and an intentional infliction of emotional distress.
Right.
Yeah.
Now we have to decide. The jury could have said 0 for defamation, 1.4 billion for intentional infliction of emotional distress, or they could have maybe aggregated them together. So that's an interesting kind of point to bring up on how they calculated it. And then generally, just to clarify what intentional infliction of emotional distress is, that's just making, doing an outrageous act that is designed to inflict serious emotional suffering onto another, and they actually suffer that severe emotional distress. And so severe emotional distress, you have to show things like you were, generally that you had to go to see a psychiatrist or something like that, or a psychologist to help you struggle with some of your emotional feelings that as a result of this negative, impacts. So I think I just suspect, but I'm not, completely sure. I'd have to see that maybe the jury found that to be an outrageous act that no civilized community would tolerate. And that the parents sufficiently pleaded that legal element with the facts. And then also they had damages, which were likely punitive in this case, if they got up to 1.4 billion. I doubt there's specific financial losses to show 1.4 billion. So, yeah.
And I saw compensatory damages. So some of these parents had to miss work. Some of them were being harassed on their jobs. There was a loss of, income. For many of the parents because of that. So I'm
that could be recoverable.
Yeah. And I saw there was a amount. I just posted up the comment. I dropped it. Oh, why did I do that?
Let me drop that link.
Saw compensatory damages were awarded. So I can imagine if these people are being harassed on their jobs and they're unable to go to work, even if to the point they were fired or terminated or felt they had to resign. you're talking about having to recover the loss of that of those wages. So
But
I
those are
don't know.
gonna like be so small in comparison to that punitive damages. Like
Damage, yeah,
that's gonna be the real money. And then ultimately too,
right.
Alex
Real
Jones
money.
can't satisfy
Mhm.
1.4 billion. I don't think
Wow.
he's worth that much. So
That
that's where you see litigants like that file for bankruptcy typically. And I'd
right.
have to check, did he file for bankruptcy? He might have actually after this to try to discharge that judgment.
Yep.
Wow.
And so I wanted to
Okay.
get to the next video that you have
Oh,
speaking on slap suits. So I think this is definitely and some of the information I want to say you're
I'm Nick Brooks.
you're speaking of now, and the questions that we're asking are gearing towards these lawsuits and this effect on free speech. If you consider a member of the press of any sort, which is Candace considers herself to be something. I don't consider her to be a journalist, but she claims she's a political, a public figure as well as an investigative journalist. Gotta help us all. So I want to get to this video, and then you can speak on that, and we can ask some questions on how much, I guess, limitation would be placed in this matter, considering the fact that she does consider herself to be a member of the press, and of course, is going to decry free speech. So, you guys put a one in the chat when you can see and hear. Let's get to it.
A California civil litigation attorney. Ever been sued for something you said, wrote, or published about a public issue? You might be facing a SLAP lawsuit, a strategic lawsuit against public participation, designed to silence you, not seek justice. Today, I'm breaking down California's anti SLAP law and how it protects freedom of speech by dismissing meritless lawsuits early. What is a SLAP lawsuit? Well, a SLAP lawsuit is not about winning at trial. It's intended to intimidate, silence, or burden people exercising freedom of speech or petition rights on public issues. Plaintiffs bring defamation, interference, or other tortious claims not to correct actual harm, but to force critics into expensive, distracting litigation. SLAPs target media, activists, online reviewers, competitors, and whistleblowers. California's anti-SLAP statute is found at California Code of Civil Procedure, Section 425.16. It allows defendants sued for acts in furtherance of petition or freedom of speech rights connected to public issues to file a special motion to strike early in the lawsuit. The law's purpose is to encourage participation in matters of public significance and prevent chilling valid exercise of constitutional rights. Here's how the anti SLAP motion works. The procedure has two main steps. First, the defendant files a special motion to strike within 60 days after service of the complaint, arguing the lawsuit arises from protected speech or petitioning activity. Second, the court applies a two-step analysis. The defendant shows the lawsuit arises from protected activities. Then the burden shifts to the plaintiff to demonstrate probability of prevailing with admissible evidence. If the plaintiff cannot show probability of prevailing, the court strikes the cause of action and dismisses the targeted claims. The prevailing defendant recovers attorney's fees and costs under California
wow.
Code of Civil Procedure, Section 425.16, subsection C. This ends meritless litigation early and compensates defendants for defending their constitutional rights. The anti-SLAP law protects statements in connection with governmental proceedings, statements in public forums of matters of public interest, and any act in furtherance of petition or freedom of speech rights regarding public issues. This includes public testimony, editorials, town hall comments, organizing campaigns, and online reviews on matters of legitimate public interest. Here are some common situations where anti-SLAP applies. First, defamation suits against journalists, bloggers, or reviewers after negative but truthful comments. Lawsuits targeting individuals speaking at government meetings or during litigation. Claims against businesses reporting violations to regulators. Retaliatory actions against community members organizing boycotts or protests on public issues. These are all prime anti-SLAP candidates. The anti-SLAP law helps defendants avoid the time and cost of full trial on claims attacking freedom of speech rights. It requires plaintiffs to present solid evidence early, discouraging frivolous suits. But not all cases qualify. If conduct is not protected, the motion is denied and the case moves forward. Misusing the motion could delay proceedings or increase costs. Several exceptions exist. Lawsuits involving purely private disputes with no clear public issue, criminal conduct outside legitimate petitioning, or certain commercial speech may not qualify. California Code of Civil Procedure, Section 425.17, contains statutory exceptions, including carve-outs for certain public interest claims where government enforcement is involved. The law is broad, but not unlimited. Act quickly. Anti-SLAPP motions have strict 60-day filing deadlines. Gather evidence, save all communications, publications, or records showing that your statements were on matters of public interest. Work with an attorney like myself because the law is complex and the stakes are high. Professional guidance is critical for asserting or defending against an anti-SLAPP motion. For more information about this legal issue, please visit my blog at nickbrooksesq.com. That's nickbrooksesq.com. And also, please subscribe to my YouTube channel for more California litigation tips.
You ready?
Question. I'm sorry.
Okay.
Yes. Okay. So let me put up what you guys have.
There we go.
All right. So let's say that the defense wants to go around to this. Oh, Your Honor, this seems to be a SLAPP suit if they don't get the motion to dismiss denied. What are the chances of them being able to successfully argue that?
Yeah, so this is a good question. So this is going on in Delaware State Court. Obviously, the video we just saw concerns California State Court,
Right.
and so and you know, it could also be involved in a California like federal court too. But yeah, it's generally California law. But a lot of these principles are in different states, exist in different states. You know, at this time, you know, it's possible. I haven't, you know, been able to kind of like see if there's an anti-SLAPP theory, you know, with what Candace Owens is bringing, but I'm not sure there exactly is, but it might be. But generally, ultimately, a defendant has to identify, you know, has what the plaintiff brought, does it involve like a matter of public concern or petitioning activity? So just to kind of clear up like a matter of public concern, it was like some of the things I mentioned, like, you know, it's possible. Yeah. I mean, if Candace Owens brought an anti-SLAPP motion, I think it's a good way to try to get it resolved. But again, you know, it's not going to be conclusive. And I'd have to kind of do a little bit of digging on maybe some of like what's going to occur with respect to like, is this a public issue versus does it still cross into defamation? Because I do think the Macrones could still prevail on their claim. You know, that's always possible. And so if they're able to show that there is a possibility that they can prevail, generally under anti-SLAPP litigation, their suit can continue. It will not be dismissed. And so that's kind of where I'm thinking if that's going to be a matter of public concern is, yeah, I still think the Macrones could probably win out on a motion like that and just say that they still have a likely chance to prevail and they can show evidence. That's where you're going to take in an evidentiary hearing and they may have to submit a lot of evidence early. I'm kind of like going through some of the procedural aspects, and then just petitioning activity is just like, you know, you can't sue a person for reporting you to like a governmental agency for like, let's say employment discrimination or something like that. And say that it was defamatory to report me for employment discrimination or sexual misconduct. Like, for example, if you saw the Justin Baldoni case involving Blake Lively, he actually, Blake Lively brought an anti-SLAPP lawsuit against his lawsuit, which said it was defamation to file in the California Civil Rights Department that I was involved in sexual misconduct towards you, and that was defamation on my character. The courts found that was protected judicial activity because, you know, submitting that complaint to that agency is a part of bringing a civil complaint. And so they actually said that's privileged, and his suit was dismissed, and Blake Lively recovered her attorney's fees. And Blake Lively, you know, that was a good job on her part to her attorneys to recognize that as petitioning activity.
Interesting.
Okay. All right, Jason, you got.
Yeah, there's a good question by MT right there. Says Nick, could Candace Owens face legal action for throwing out?
Oh, let me pull that up.
Erica Shapiro and her ex, who is at Daily Wire employee, might be involved. Like, and I would only add to that, like just some of the baseless, egregious claims that she's thrown out there.
Exactly.
Like just like, hey, only people who wear, that light purplish sport coat are criminals. Like, like just the craziest stuff she throws out there. Can
Right.
that stuff come back to bite her? And of course, MT's question as well.
Yeah. So ultimately, we're going to have to evaluate, is it a false statement of fact or an opinion? And so that's always going to be like one of the most crucial first things to decide. So I'm not exactly sure of the exact statements.
But she said this last night, so you'd have to really be dialed in to hear it. She said it
Okay.
last night, but just even in the whole thing, like TPUSA was involved in it, like in the deletion of Charlie Kirk. Like, wait, what?
Yeah.
Or insinuating the Macrons, to
Macrons, right?
wanting to assassinate her, like those types of, just inflammatory. It's so defamatory, to accuse someone of having committed a crime against you with no evidence. But I think what they're asking here is similar to that, like saying that they are part of this conspiracy regarding Charlie Kirk's murder, and
Yeah.
so
I think
saying they're involved in that.
it's going to come down to just like how concrete and like would a jury feel it's concrete a statement of fact? Because like imagine I made a statement to you, you said X person murdered Y, and I'm like, yeah, sure he did, and I winked my eye, or he did not murder him and I winked my eye. Like that's a communication, and you could use the wink against me. It's just like, how convincing will that be that I made a concrete statement of fact? And so like I think Candace Owens is rather kind of savvy in that sense, where she does kind of try to walk some legal lines. Because, if you walk some legal lines, sometimes you can get attention for that as well. Because, whenever you're kind of involving somebody's reputation, it's going to get a lot of views. And so like,
Sure.
did she say a statement of fact, or is that an opinion? And a lot of what you hear comes down to like, as soon as like one side says, oh, well, that's a clear statement of fact, the other says, no, that was a question, or that's an opinion, or that, and so there's a lot of defenses that get brought up. So I think there's been a lot of statements. You would just have to evaluate each particular statement. And then, ultimately you'd have to select the ones you want to submit to a jury. And would the jury find that to be a concrete statement of fact? That's a question of fact, I would say to me. You would submit to the jury, is a wink from me to you actually concrete enough to hold me liable? So ultimately questions of facts for the jury. And so it's always difficult to predict the jury, right?
Right. Exactly. I do have a great question here, and I've covered
that's a
this
good one.
information myself. Regarding the HIPAA violation. Well, there's a medical staff hospital employee where Charlie Kirk was admitted, that sent a screenshot of the EMR where you can
Yes.
clearly see identifiable information of the patient, and emailed it to
Crazy work.
Candace, which was the hospital staff committed a
That's
HIPAA
crazy work.
violation because they're a covered entity. But Candace disseminated that information on her channel and posted up that screenshot of the EMR. You can see you can see Charlie Kirk's name, his date of birth, the department type. I mean, specific identifiable information. No one walked away confused about what patient she was referring to. You can see the information from this electronic medical
crazy.
record screenshot.
Yeah.
So the question is, do you believe that she could be held legally liable for that? And I covered CMIA as well, and I personally said that if Erica Kirk wanted to sue, she could, according to CMIA, be held liable for invasion of privacy. But what are your thoughts on that? Just anything you can provide on that.
Yeah. So, I mean, really, maybe there's two entities which could be held liable for, dissemination of private medical information, of Charlie Kirk. Obviously he's passed away at this point. So sometimes like your legal rights change on whether you're alive or whether you're passed. For example, Charlie Kirk would not be able to sue for defamation because Charlie Kirk's passed at this point, and generally only alive people can sue for defamation. But going back to your question, can you ask that one more time?
I'm asking basically what
the
should be
HIPAA.
legally liable for
And
the information that she shared. That, I mean, she would need, the next of kin would be Erica Kirk. So she would need consent from Erica Kirk to be able to post something like that. So could she be held legally liable? Could Erica Kirk sue her?
With
I'm just
respect to the
curious.
HIPAA violation, that's an interesting question. I know I've had to send out, I've had to get HIPAA authorizations from clients before I, their medical providers will send me information. They want to see that I've gotten the proper authorization. I don't really know. I'd have to do some research, right now. Cause like, again, Charlie's kind of passed at this point. I don't know. I've always dealt with alive people with respect to HIPAA. So when we're dealing with a past person, I just have to see. I mean, it's likely, yes, that, you can't public private medical information of individuals. And there are statutes out there which provide you can be held accountable for doing that. It's just a matter of identifying those statutes. Is it HIPAA? Is it another statute? And then if it's not a statute, I'm sure maybe there's some common law theories. I generally publication of private facts. That's still, you got to be alive to bring that. So
Right.
I just have to do some more research, honestly, on a question like that. But it's interesting.
I did cover some information regarding CMIA. And that's kind of an act where you either received information illegally, meaning there was a violation of the HIPAA privacy law,
Right.
where you received it and then you disseminated it without consent. That could, hold you liable for disseminating that without consent based on the way you received the information. So the hospital staff did not have consent at all. They did a screenshot. So the hospital staff is a covered entity under HIPAA. They sent this to Candace Owens. They emailed it to her. They just sent it to her. And it was also another
Tip
email.
line.
It's an internal email between the nursing staff that was somehow screenshot and leaked out. So now you have internal, communications being sent out, a screenshot of this EMR being sent out where the patient is clearly identifiable. And
Wow.
they did not get consent from the hospital. They didn't get consent from Erica Kirk. But Candace took that information and then disseminated it. And she didn't get consent. And the way she received it was through this HIPAA violation from the covered entity. So CMIA says, the way you receive the information matters. If you acquired it illegally, that could make you liable, not necessarily for HIPAA violation, but make you liable for just the invasion of the privacy and for failing to get consent. So
Got it.
I don't know if you're familiar with CMIA.
I don't know the
But
acronym exactly. No, you're referencing.
you know what? Let me pull it up too.
But
'cause
yeah,
I'm
generally,
sorry.
you got to protect private medical information, and you can't let that get out. So it's like, for
Right.
me, I just have this instinct that there's some statute out there that's gonna, be able to hold accountable the people that disclose that information. And then, obviously it'll be at the hospital level, maybe. And then with respect to like Candace Owens, it's possible, I'd have to check some of the statutes and things involved and what her protections would be. Maybe there's a case out there that doesn't protect it or one that does. So yeah, it'd be some legal research I would have to engage in.
Ironically,
Gotcha.
it is the California
Callie.
the California, hold on. It's for California Confidentiality of Medical Information Act. So CMIA is specific to the state of California, but I have to see if there is something similar for the state of Utah because
Yeah,
it came
and I
from
mean,
that
in
hospital in
situation,
Utah.
yeah, I mean, if I guess the hospital's in California.
It's in Utah, so I have to look up if there's any state specific regulation in Utah
Yeah,
that would be similar to what the CMIA is. But even just the aspect of taking this, medical information here, it's an EMR screenshot and the internal email from the nurses. And she shares this on her channel, but she never got consent at all. Nor did she even ask, well, who sent this to me? Did you get consent before you sent this to me from the hospital staff? She stated it was a hospital worker that sent her that. So I highly doubt she asked, did they get consent? And of course, she shares it on her channel. And it's nothing that we needed to know. I mean, it didn't help towards anything. It wasn't proving a point. All it did was, okay, well, he went to this hospital. We know he went to the hospital.
Right.
You don't have to show an EMR to show that he went to
He
the
was there.
ER. Yeah, it's like we did not need to know that information, but you can clearly see, specific information that EMR that also is specific to that system that they use. And it's just like this this showed nothing. It doesn't tell us who the killer is. It doesn't speak to any of that. So I guess what if Erica Kirk wanted to sue and she's saying, okay, well, you guys invaded my husband's privacy. No one didn't get consent. Um, I guess what would be the likelihood of something successful, a lawsuit being successful in that situation?
Yeah, so I suppose they probably have to bring it in Utah State Court if it involves a Utah, hospital and things of that nature.
It
And
does.
you'd have to bring it under the proper Utah statute, which would probably be one that protects against dissemination of private medical information like we have here. But again, I don't practice Utah law, so I'm not exactly sure what statute that would be, or
Okay.
don't want to imply that, but yeah, that's kind of how I'd evaluate it. And then with respect to Candace Owens, liability for the same dissemination, it's tough. I haven't really thought about that and how it would work out if she could be held liable, because there have been times when I guess like you remember the Pentagon Papers leak. I don't know why that just comes to me, but the reporters leaked the Pentagon Papers that came. It's like, well, then you hold the disseminators of the Pentagon Papers liable. I mean, it's not private medical information, but it's still privileged protected information, and you really want to hold accountable more so, I suppose, the source of the information which disclosed it, such as the Pentagon or the hospital or something like that. So because that's where I think the most liability is probably going to lie. That's just my instincts.
And just for the comment here, it was Charlie Kirk. His name and date of birth was actually shown. He didn't go in under an alias, so you could actually see his full name and his date of birth, which is public information since he was a public figure. And of course, it was the type of admission. I mean, just information related to the hospital. And it's like, why is she showing this? Go ahead.
Let me ask another question then. Let's just pretend that Candace redacted everything. So she didn't, let's say she showed that information and it was redacted. So Candace wasn't showing it recklessly. However, the file that was sent from the nurse wasn't redacted. So you are putting out somebody's, I got Nick's information. I send it to Lady Luck Club. Lady Luck Club redacts it. She's responsible with it. But Nick's information was still sent by somebody to somebody without proper permission. I'm just wondering, is that still a problem? Does that make sense?
Yeah, it makes sense. Obviously, if you redact it, there's a little bit more protections probably that she could argue, like, oh, I took steps to prevent certain information from being disclosed that would be otherwise identifiable. Again, I kind of go back to I think you have to hold accountable more so the sources which disclosed it and were
That's what I think,
held
the hospital staff.
Yeah, because then it's like if the third parties get it and then they disclose it, what is their liability? I'm not sure. I'd have to actually look that up. I didn't really prep for that one, so it's really kind of difficult for me to answer that one.
Well, when you come over to the J-Wit podcast, Nick, I'm going to give you time and let you know. We want you to be ready for that one. There was another good question, though.
And if you guys have any questions in the chat, make sure you just put a Q in front of it so that it stands out. That way we can get your questions up.
Yeah, I've heard that before.
But so I want to make sure that I got all the questions I had in my mind. Any more questions you want to ask J-Wit while I'm thinking?
No, just real quick, just in case people just hopped in. Nick, could you just give us a little bit, give us your resume. Who are you? And the bet is that I said you're Southern, and somebody, I think you might have already told them already. So anyway, I don't know much about you. I figured you're Southerner. Some people are saying you're from Tennessee. Well, I just want to hear all that. So go ahead.
I definitely. I said it at the beginning, but I'm from Tennessee.
Right.
Are you from Tennessee as well, J-Wit?
No, sir. I'm here in Georgia.
Okay,
We're
I
in
thought
Georgia.
someone in the commenters said you were from Tennessee, so I wanted to follow up on that.
Oh no.
Okay. No, I was born and raised in Tennessee, in Columbia, Tennessee. It's about an hour south of Nashville. I went to school, like undergrad university, Tennessee Tech, about an hour east of Nashville. And then I went to Rutgers Law School. I finished there in 21, so not many years ago. And then
we had the COVID pandemic when I was in law school, so we had to vacate campus. I really didn't want to move back to New Jersey because of the cold, after I had to leave. So I decided to kind of start my practice in California because I had some friends here, and I love sports, and I always thought maybe I'll be like a sports attorney, sports lawyer.
Okay.
I really didn't know what all that meant. But I finally kind of passed the bar. I've been doing primarily civil litigation since I've started. So a lot of civil litigation just involves the bringing and defending against different civil claims. So a lot of my job comes down to like identifying what are actual reasonable causes of action that you can recover on. What are the elements of those causes of action? What facts do you need to prove those different legal elements? And then if you're on the other side, like what are the proper defenses to bring? What are the elements you have to show? Like, and all, you got to gather evidence to demonstrate the facts and things of that nature. And then, within different, the civil procedural aspect, a lot of what I deal with is more pretrial. So a lot of it's just discovery, motion pleadings, doing a lot of appearances at hearings and things of that nature.
For sure.
And I've done some, appeals work too. So a lot of legal research and writing in that aspect.
Well, cool. Well, I'm glad to have you. So what got you interested in coming out here on these YouTube streets to talk about whatever it is that you are discussing, which, by the way, I do think you do a great job. What made you want to do that?
Yeah, no, I appreciate the question on that. So really, I started kind of doing like owning my own practice and kind of being a solo. So a lot of it's, me contracting with other attorneys, like in the Southern California area, get some work for myself, but also, when you're an independent contractor, you get to operate independently. So I get to take time for myself and like, how do I get a little bit of like some exposure online and stuff like that? And obviously, you're always looking for some type of niche and stuff. Right. And so a lot of it, I thought it's like legal analysis. And, when it comes to like starting the whole like Candace Owens stuff, I really didn't even know that it would kind of blow up. I just did like, some random kind of legal videos. And then suddenly I did Candace Owens and I got like 21,000, 30,000 views in a short amount of time. And I was like, wow, that's a lot. And then I did another video on the Bridget Macron case. And that one blew up to like 30,000 views in like 5 hours. And I was just like, that's nuts.
Yeah.
And so like, there was definitely a strong demand, I thought, for like people wanting to understand like what's going on with Candace Owens' legal affairs. And it's even to the extent that like, I try to do other celebrity legal affairs and analyze them, but a lot of people don't have the same demand and appetite for that. Like Candace Owens commands a lot of eyeballs and people really want to know some of the things she's saying because a lot of people do find them, whether it's morally objectionable or potentially legally wrongful, they want to know like more aspects about that. So, it's just a combination for me of trying to blend like what insight I can provide, maybe, get some exposure for myself, whether it's defamation law, First Amendment law, those cases can be good. I would know how to litigate them. So maybe somebody out there one day kind of sees me speaking on, different issues. And so that's kind of how I got into YouTube, was just how do I get my brand out there, establish myself and see what kind of happens from there.
Absolutely.
I like it.
I have a question from No Reply. Shout out to you. Thank you guys for tuning in. If you guys can, make sure you're hitting the like button in the LLC, as well as on my brother Jay Witt podcast, and continue to ask these great questions. And you guys make sure you check out Nick Brooks. Let's get his channel growing. Let's get him some more exposure because his insight is valuable to all of us. So No Reply is asking, what are the implications of me submitting all of the lawyers' addresses, defamation information to Claire and Locke, as well as security report to RLF? That is her attorney, Candace's attorneys. Candace LLC is familiar with it. What are the implications?
Who's Claire and Locke?
Claire
Locke is the Macron's lawyer.
The Macron's attorney. The attorneys for the petition.
They were also the attorneys that sued for what was the voting machine? I can't remember.
Oh yeah, the
election fraud.
What was the election machine?
I forget.
It'll pop up in the chat. It'll pop up. Somebody remembers the name of it. Election machines are us. I don't know. Whatever the machine was, they're the ones that sued for that.
Yeah, they got a big judge.
Dominion. There we go. Dominion. I knew it was coming.
Yeah. They got 776 million or something like that out of that judgment.
That's a little bit. You could do something with that.
Yeah, that's what led to the termination of Tucker Carlson from Fox News. When you break down the correlation of events.
Oh wow!
Really?
So,
Okay, yeah, good catch.
and let's see here. Was your question answer no reply? Let us know if we
Oh, let me,
addressed your
what are the
question.
what are the implications? Let me
Submitting all of the lawyers' addresses.
I don't know the security port, but the question means.
Are you referring to because Candace put out her attorneys, even though it's in the
You don't.
filing, but most people on
Yeah,
average don't read stuff.
you
So
don't
the
want that.
address of where the attorneys work, she put it out. And there are dozens of people that work in that building and
Mhm.
probably would not want random strangers coming up to them,
Hey, I went
Yeah,
there. I
leaving
went to
the
the
building.
building. Leave me alone.
well,
You
and
call
I'll
me a
say
random
this.
stranger?
Yeah, it's public information. Like you can, I
Right.
mean, you can look up, for example, even my
I get
own,
it.
bar information and stuff. So it's like she can always have that defense that, hey, it's already public. It's out there. All I'm doing is
Right.
sharing public information.
Information. Okay. And Sarah Kelly is asking, are there any YouTube rules or anything being broken by CO? I mean, YouTube is so finicky, but maybe I can ask this. Why is it that, if you say something that is
Oh, I got
because
one
you're on
for you.
YouTube now, you're a content creator, so you
Right.
say something or do something that the YouTube people deem to be inappropriate, or especially if you're monetized, they'll restrict monetization in a minute. Why is it that she gets to freely make several false statements that I've come a couple of them I literally have debunked with basic information, and still have her videos? She still has a channel. I mean, why hasn't YouTube taken down any of her content?
It's an interesting question. I would say my best analysis on it is that a lot of the issues are very politically sensitive that have a lot of followers on each side. And when you're dealing with a commentator like Candace Owens, she's quasi very political in that sense. So you have to consider that. And so if you ban her for her certain speech, a lot of people will take that as, well, you're trying to suppress political opinion. And YouTube's been accused of those accusations in the past. And I'm sure they want to distance themselves from like picking sides on the political spectrum, because for businesses, I don't think it does very good to overtly look too political. They're always trying to at least strike it down the middle best they can in order to increase profits, I suppose, from each side. And so, but I'll concede this point that I've had one person in my comments say that they feel like some of the content she dives into, especially with Israel, can border, on anti-Semitic, conduct and, statements. And it's an interesting thought because if you say, something, about another group, you could be banned. And then she's saying this and, she's not getting banned. And so I just think it's a case by case basis. It's difficult when you're a big business to try to navigate, impose restrictions on every single user. And the bigger that user gets, obviously, I think if you just ban them, it might not eliminate their following. Those followers may just migrate to another business platform that allows that. And so YouTube has a interest in retaining the business because, monetization is a business model, and you want to empower the creators, even where they're controversial. But obviously you don't want to violate terms of service because you give grounds to YouTube. And it's likely too that maybe she has violated certain terms of service, under certain arguments people could make. But ultimately YouTube has the right to control who gets the platform and who doesn't, and where those violations occur. And just because they're unequal, they're not a public entity. They can somewhat be a little unequal in how they regulate that. So it's a little bit arbitrary, I would say, at times. But it's just the reality of trying to keep eyeballs, I suppose, and do the right thing.
Right.
So there are content creators who there's a content creator, female content creator, who is making her whole brand to be extremely bombastic and derogatory toward Black people. Very, very egregious. Even any benefit that could have come from what her critiques were lost very quickly with her use of the N-word and just being so out of control. YouTube took her monetization away. And
I saw that story. Yeah.
Lily Gaddis knew that was coming. I think the argument could be made that Candace has done maybe not as egregious, but Lily Gallus was already way over her coverage when she started. She was she already knew she already knew what was going to happen. So I think that I think the argument could be made, but I don't want Candace to lose her monetization. I don't want YouTube to do that. I want the right thing to be that the people recognize that she's feeding them tripe and them stop supporting it. But I don't want YouTube to step in, because I do think they will, put themselves in a trick bag where they look like the bad guy, and it actually looks better for her than it would if YouTube just let her rot on the vine. But that's just my little observation.
It's kind of like, to me, like, I don't know if you're football fans, but when you're watching a referee try to make a call, if the ref does insert himself, inevitably they're kind of blamed for it when you just let them play and just see who goes out there and wins it, right?
For sure.
I think there's good side, ultimately, if the litigation doesn't turn out how Candace Owens want, right now we may not be talking in negative, circumstances about that, but it could turn, more, you could take shots at it and say, well, you didn't win that motion to dismiss, and you could maybe take a little bit more shots that way. But yeah, with respect to some of the I've definitely seen it. Some of the whole racial or ethnic and national origin or religious kind of discrimination from different, pundits. It's very unfortunate. I don't think really the platform should serve that. And, public entities can't do that. Like if you're a government agency and you try to engage in that, you should be held accountable by, either the feds or somebody should step in for that. When you're a private platform, they have their terms of service and they can govern it. And then sometimes it's tough to make calls on, what's contemporary a little bit more. Like, for example, I'm not sure you saw the Puka Nakua rubbing his hands together on that podcast, and then that got a little bit of traction online. That's a little bit more contemporary. I think, what's his name? The white Nick Fuentes was doing that on his podcast, rubbing his hands together to really imply that the Jews are not good people and stuff, and that's what they do, and that's wrong. And so that's kind of contemporary anti-Semitic slurs that are arising as we just see them develop on YouTube. And now suddenly, sometimes they can be mainstream at that, and amplify. So I think social conduct can change quick. So law has to change quick too, to identify what is discriminatory and why is it discriminatory. And how if you say certain slurs, does this slur rise to the level of this slur? And it's difficult.
Right. I have a question just on the Macron case. So the Macrons, of course, live overseas. Do you think that this should have been a matter they filed in their court, even though I do believe that they're standing for them to come here? But
in France?
This is a question that's being asked here. The actual question here is, what's protocol on overseas litigation? But I don't think would you know anything about that?
Yeah. So when it comes to, we have to identify the proper venue, essentially. And so would venue occur in France, or would venue occur somewhere in the United States? Well, when we're evaluating venue, typically, especially at the federal level, you want to identify where did the acts or the transactions occur? And here the acts were statements made. They occurred in the United States. They didn't occur in France. And they might have made their way over to France eventually, but those statements occurred in the United States. And when you look at the lawsuit, the business entities of Candace Owens are named, and those business entities are registered in Delaware. And when you register with the state, you accept service of process when somebody brings a lawsuit against you. And so essentially you're stating the venue's proper here where somebody sues me. So that's why the Macrons chose a Delaware state court, because her businesses have, established themselves as this is a proper state to litigate litigation that comes up against this business, which has occurred here. And so I see some commentary about, her trying to change the venue to Tennessee at times. The only issue is you can't really do that because we're talking about state level courts. Delaware can't, Delaware state court can't transfer a court to Tennessee state court. The Delaware state court actually have to just dismiss the case and then let it be refiled in Tennessee. But that's not going to happen because venue is proper in Delaware. And so, if she brought a motion to dismiss based on venue, I think Macron's attorneys would argue, no, your business is properly submitted, that they would be, amenable to litigation in this state.
Believe it or not,
can I,
that is what the motion to dismiss is. It's
that is it.
based
Yeah.
on libel
Well,
tourism and it claiming
it's
lack of jurisdiction.
yeah,
Yeah.
there's three parts of it, and one of those is that you're right. Does it matter at all, Nick? Let's just say that it was all things are equal, and it really was an argument about whether or not the case should have been brought to Delaware. Does it matter at
Right.
all that Candace has sued entities from Delaware?
Right.
She sued
USA
USA Today from Delaware.
In Delaware.
Does that matter? Would that actually be like the straw that breaks the camel's back, so to speak?
So basically, to use her previous lawsuits,
Yeah.
bringing Delaware companies, like as her understanding the law and how that works.
That is correct.
Yeah.
Mhm.
I don't. Here's the deal. I think if you brought that, sure, you can bring it, but ultimately, I don't even think you have to consider that for purposes of just declaring this is the proper court. Here's the proper court because your business is registered here. I would stop the analysis there. I wouldn't go to any prior, litigation she brought. I think it could maybe, like we talked about, risk confusing issues. I think a judge would see through it, but ultimately, I don't really think it adds to the legal analysis. I would just say venue's proper because your business is registered here.
Right.
I got
And she
you.
confirmed
No, I
that
agree.
in a video that her LLCs are registered in Delaware. So she destroyed her own
talks too
defense with
much.
that.
She talks too much. I'm
Oh,
gonna be
it
honest
was
with you.
epic. She said, "Yeah, I have LLCs that are registered in Delaware." I was like, "Okay, well, there's your defense destroyed, lady. Like,
Right
you
after that.
you can't say, oh, it should be dismissed because the defamation occurred in Tennessee. Well, it's not because just that. It's because your LLCs are registered in Delaware. So,
And ultimately, the
Yeah.
Macrons could have chosen, did they want to bring it in Tennessee or did they want to bring it in Delaware? And so they chose Delaware. And a lot
they
of
chose Delaware.
Yeah, a lot of your major corporations in the United States are registered in Delaware. And so, and because they have really sophisticated court systems that know how to address certain corporate law issues. I mean, defamation is what we're dealing with here. So it's not exactly that.
Right.
But, I think, forum selection for the Macrons, and they chose Delaware as the suit. I've seen some
Right.
comments on my page about, there being a high French influence in Delaware. And I just kind of laughed at that because, Delaware was the very first state.
Yeah.
Yeah.
And so I'm like, well, I don't know if the
Yep.
French are still influencing if it's been a first state and since, for over 200 years, but
Yeah.
Yep.
I think people they're picking up on whatever reason to
Right.
believe that this is going to be stacked against her because she knows she's going to fail. In my opinion,
Yes.
I'm sorry, based upon my own information belief, she's going to fail.
Yep.
So she's already kind of framing it so people can accept the loss and say, "Oh, see, we knew Nick was no good because we already knew that anybody that wears a tie on Saturday can be no good.
That's right.
So therefore, he's wearing a tie on Saturday. I knew he was no good. So anything you come
of
up with
course.
is no good."
Yeah. Right.
Yeah, litigants
And-
always try to find ways, like who's to say, right, that let's say Candace Owens can move for a physical examination in the Bridget Macron case. Let's say she's denied and the judge says, the reason I'm denying this motion is because there's other sufficient evidence which proves certain issues or sufficient evidence to show you don't need this.
Right.
It's too invasive and a violation of privacy rights and dignity. Who's to say Candace Owens can't just openly disagree with the judge and say that I don't like that and it's unfair. And I still think she has that, potential pathway to just, but it's like,
Right.
it doesn't matter. The judge is, the one interpreting the law. She might not like it. But, and it can make her look bad to the judge if the judges are good people typically. And then I don't think they're going to be, trying to look up daily what Candace Owens is saying about them, but it's probably going to get
Right.
around to some little comments if they go too far.
Right.
Yeah, don't be like Johnny Somali.
Yeah.
I want to ask about, the insinuation she's throwing at Kirk, TPUSA, and her meeting with Erica's meeting with Candace Owens.
Mhm.
Do you? I guess let me ask this: do you think it was valuable for her to even fly out to Tennessee to have this conversation with Candace Owens, only for Candace to come back out, basically making the same insinuations and statements that Erica Kirk is involved or is connected to people that she's accusing to be involved? What was the purpose of even going out to Tennessee to have this conversation with Candace Owens? What do you think should have came out of that?
That's a good question. I think it's kind of, I'm definitely kind of speculating to an extent on what
Yeah,
maybe
Yeah.
was
of
said in
course.
that conversation. Cause
Of
there
course.
could have been a multitude of things said. I don't know if you saw
Yeah.
one of the Cuomo brothers, he got on his show on News Nation and said that he thinks it's all fake. And I was like, oh, that's an interesting take. Like
God.
who's to say?
Jesus.
I doubt, I don't know if I'm subscribing to that, but yeah, when it comes
Uh-huh.
to like what they said, I guess I could maybe suppose that like, Erica Kirk kind of said how she felt about the situation, her own
Mhm.
emotional thoughts and feelings about it. Maybe how this
Mhm.
is reputationally harmful, whether to her, to TPUSA staff members, to the organization itself. And a lot
Mhm.
of it probably was just imparting different facts that could later be used to establish that like Candace Owens knew after this conversation where we
Mhm.
presented X, Y, and Z evidence or, certain things
Mhm.
that what she
Mhm.
said thereafter was, wrongful. And I mean, that's just, maybe plotting how to set that theory. And as I understand, like,
Mhm.
or were there attorneys there at that as well? Or was it just those two? I'm not so
Mm,
clear.
It
They were.
was Erica and the COO. And
Mhm.
then at some point in the questions that Candace brought up, she then brought in TPUSA's attorneys on the phone.
On the
So
phone.
she
Yeah.
contacted them. And it was about the criminal matter to which they're not a party to. They're not attorneys representing the state or the defendant. So I don't know what the TPUSA attorneys were supposed to give to Candace to make her happy with any answers, but they did call. Erica did call TPUSA attorneys over the phone to ask about some of the evidence that Candace is demanding from the
Right.
criminal, from the murder trial, from the investigation with that. So I wish she would have brought her attorney with her, but she didn't. So she
Yes.
called her.
It's
I
tough.
just
There's a lot of things that could have been discussed.
Yeah.
go
Well,
ahead.
I'm going to say something. I think a lot of things were discussed. If we talk, Nick, for 4.5 hours,
Right.
we're talking about a lot of stuff, man. We're getting a lot of stuff, and I'm sorry, and we got issues. So it's not just like we're just meeting each other,
Right.
but we got some real bones to pick. That's a
Right.
lot of time to talk, man. I think
Yeah.
they did talk about a lot because if you
Yeah.
just and I do a live stream every day when Candace goes live, so I've
Mhm.
listened to a lot more to Candace than probably is recommended by the FDA. So
Mhm.
that being the case, I've heard, and like she probably explained probably about 30 minutes of the conversation out
Yeah.
of four and a
And
half
nothing
hours.
else.
I'm giving you minute by minute, 15-minute blocks of everything we talked about because I know everybody
Right.
wants to hear this. She gave him maybe 30 minutes, maybe. So the reason I say that is I think they talked a lot, and I think they said a whole lot. And the reason I say that is because what has Candace said afterwards? She's talked very little about TPUSA. She was going hard in the paint about TPUSA was a bunch of mobsters and gangsters, and they'll give you cement shoes and all this kind of stuff like that. She comes back and everything's sunshine and rainbows. She talked about a whole bunch of new topics. Now, granted, she got that guy to come in and kind of implicate Erica into some crazy Huachuca conspiracy, but she kind of
With no
stopped a lot on
security
this.
camera footage.
Right. And she stopped a lot of that. So I'm
Mhm.
wondering if she was shown more information than she divulged. And Erica said, no, this is what we have. Now, if you keep running your mouth, we do now have proof and evidence that you have this, you've seen this,
Mhm.
and now we can file defamation against you because now you now know. And not only, we didn't just email it like Claire Locke did. We came and brought it to you. We got your fingerprint on it. We know you saw it.
Right.
And now
Right.
that's what I think happened. I think there was a lot more information was shared than Candace would ever divulge because she has really tampered down. She almost gone like she's tampered down a lot. My joke was if she comes back talking about knitting and all that kind of stuff like that, we know that TPUSA brought a lot of evidence. If she comes back talking a little less, then we know a little less about TPUSA. We know they gave her something, some kind of offer that she couldn't refuse. So that's what I think happened. In my opinion, I don't know it emphatically.
Yeah, no, that's a good point. And my
Yeah.
biggest concern is just like, in criminal trials, the prosecution has to prove its case beyond a reasonable doubt.
People doubt.
And so in the prosecutorial theory, as I understand in the state of Utah, is likely going to be that, Tyler Robinson acted alone and he, was involved in the assassinations, as the allegations currently stand. And so like with that, where Candace Owens does put out these different alternative theories, does that create the sufficient amount of reasonable doubt? Could the, attorneys for Tyler Robinson look at that and say, there's a lot of people out there that believe that. We might just look at the comments section and maybe gauge a jury that way. Like who's to say that the jurors aren't going to think similar to certain commenters, and what certain theories out there are more plausible than others that a jury would accept to sufficiently find reasonable doubt. So that's one of my concerns with that. It's an interesting one.
And also, okay, go ahead, Mike. I said,
go ahead. I was going to pivot to Tyler Robinson, but go ahead.
If you could pull up Captain Jack's, because we didn't say it emphatically. If you could pull up Captain Jack's, thank you for the $5 super. They called Erica's attorney, not the prosecutor. Erica's attorney has only the information that the prosecutor counsel or PC in the PC and charging documents. So I didn't want to, I might have misspoke when we said that.
Did she say there was TPUSA's attorneys?
Yeah, she did.
Because TPUSA, okay, TPUSA attorneys, are they the same as Erica's own personal attorneys?
Generally, no.
Yeah, I was about to say, I think there would be two different sets of attorneys here.
Yes.
But neither of them would have more information about the case.
They wouldn't have anything about the criminal matter. Not at all.
So it would be like me calling Nick. Like, Nick is my attorney. I appreciate you, but you don't know more than I do.
No.
Sadly,
neither of them would have. Yeah, no, not at all.
Yeah, and two, they probably got a lot of their information as a result of they were likely investigated, by authorities in Utah to, what do they know? What did they, what happened leading up to all this stuff? So because the prosecution has to build their case, and they've got to make it bulletproof to avoid any type of arguments from the defense related to reasonable doubt. So I'm sure they definitely learned some facts, just maybe even indirectly by being asked certain questions, like, oh, that's an interesting question. Well, let me answer that, so it's interesting.
Yeah. So the Tyler Robinson case is, I guess, it's starting to pick up in court. There was a hearing, was it last week, regarding member of the press live streaming inappropriately in the court. It was a violation of the standing order on decorum. And, this is standard order for all of the cases in court when it comes to, press release. And now you have the, I believe it's the prosecutors that are pushing for a restriction on that. What are your thoughts on, the prosecutors' motion? Yes, like having members of the media in the hearing, in the courtroom. Do you believe that is some sort of infringement upon free speech and free press?
No, it's a great question. And I've actually spoken with judges on how they do it. And each judge can kind of handle their own courtroom on how they see fit. And, ultimately a judge has got a lot of power in society, and with great power, comes great responsibility.
Right.
So if you're allowing in media, the reason you generally have to allow in media is the media themselves have to make a motion to be allowed in. And so then when they make a motion, the judge will consider the different public implications. Like maybe there's a huge public interest in a case like this. And clearly in a case like this, we have a ton of public interest. So allowing in media members to do different activities, that's fine. It's just if the judge permits any type of media activity, like you said, there's going to be a standing order related to what's acceptable media activity. If live streaming is not a part of that order, you're effectively violating the law, actually, because, the law says don't do this, and you're kind of being granted an exception by the judge. And so if you exceed that exception, you're basically back into violating the law. So I can see why he definitely made an issue of that. I think by making an issue of that, it just kind of it kind of taints the decorum that, maybe Robinson's side can say, oh, this was a ridiculous type of proceeding or something. And you don't want to give grounds to that. You want to make sure that everything goes as perfectly as it can. That way later on, he can't look back and point to anything that would give him grounds to object.
For an appeal. Yeah. They're going to hand him an appellate case if they keep doing this. They live streamed a hearing. They were not supposed to be live streaming. And I think they picked up some audio and that was of conversation that was being discussed with the attorney and Tyler, I think, or between two attorneys, is still privileged. So it's like they people don't want Erica Kirk wants the cameras there. She wants, this to be live streamed, but if it comes down to it, to the fact that it could end up hurting the case, especially during, any of the hearings that's going on. These are preliminary hearings. This
Yeah.
was a hearing on a motion. So it wasn't even, getting to the actual trial itself. I mean, just preliminary hearings addressing motions, and now they had to have a motion for possible violation of that order.
Mm.
The risk is too great. They've been wanting to try to kick out the media since the beginning. So to do something that would make it worse, if from a member of the press, it's hard to say, hey, we want free speech, we want free press, but then you're going in and you're violating court orders. It's hard for the judge to want to,
Yeah,
give Erica Kirk what she wants with that.
I would.
So, go
I
ahead.
would sanction them if I were the judge. I would just sanction
Yeah, I
the
was
media
about to say.
member. I would
Uh-oh.
sanction them for like $1,000 to $10,000 probably for violating the standing order, and because that would
Right.
send a message like deter. You're not going to do this. If anybody else does it, the
Yes.
sanction might go up because like
Yes.
you want to appeal to both sides. You want to deter any
Yep.
violations of the standing order related to media, but you also
Yep.
want to satisfy that if the public demands they want to see this trial because it's that important to them, that's also a
Hmm.
huge consideration as well. So it's like, what solution do you find? And I think sanctions on the
Yes.
violating like media members would be sufficient because their employers are going to have to pay that. And if you're an
Yes.
employer paying $10,000 for a sanction violation, you're going to
Right.
have a strong talk with that employee who did it.
Yep. Absolutely. And
Okay.
probably, you will give the court credence to have that person banned
Yeah, and then
because,
also
Nick is,
there's
give you
Nick is
well,
a
you preserve
gangster.
the integrity of the trial as well. So it's like if you
right.
impose that, it's like people are like, all right, this is serious. This judge isn't just playing around and letting people violate the rules. Like, you're going to have
Right.
to do things the right way, and it just gives more decorum and integrity to the proceedings.
Absolutely.
Y'all put
Absolutely. So
hashtag 10K Nick in the chat.
Yeah.
Nick is gonna charge you 10K,
he
man.
said
If you
I'm going
don't,
there. I'm going all the
Nick
way
said I'm
there.
going all the way live, man.
I
I
said
love
that.
it.
I did
Okay,
it.
no,
I did a
that's
video on that. I said, "Oh my God, they need to sanction them because this is going to taint the jury. Is going to, create this biasness about the matter. You're going to give the defense, more credibility to say, well, we're not receiving due process. It could get to the most extreme point, and that would be my question as well. Do you think if it continues on, that they could seek, a different venue here? It could, they can have a better argument to say, you know what, why don't we just transfer this to a different venue where we might be able to have, a more secured trial and hearing, and my client can be ensured due process here. What are the chances of that? They just
Yeah,
ask
so
for a
since
transfer.
the crime occurred in the state of Utah, I think Utah State University or one of those
Yeah.
universities in Utah,
Mhm.
and so
Yeah.
with that, you have to prosecute that in Utah. It wouldn't be appropriate to prosecute it in Nevada because the
You're not gonna move
acts
to
didn't
Delaware.
occur there.
No, I
What's
mean
that?
move it to a different. Move it to
Yeah.
a different district, not necessarily in that
Yeah.
court, but take it to another court in a different district, but still in the state of Utah. Not taking
It's
it out of Utah.
possible, but you would have to meet the statutory elements related to the change of venue. And I think,
Okay.
this, I don't know the exact Utah requirements on that. So, and I'm not a
Okay.
Utah attorney, but it generally, like if you're trying to change venue within a state on that, it's because you
Mhm.
feel like you can't get a fair trial in that
Right.
particular county or something like that. So like,
Right.
let's say I had some case here in San Diego that was like a criminal case that was really a lot of people knew about it. It upset people, and I was worried about a tainted jury. I could then just file with the court, hey, I want this done in some county way in North California, or maybe even LA or somewhere east of LA, north of LA. And that would tone down some of that prejudice,
Mhm.
maybe. I mean, obviously, when we're dealing with something like this, Charlie
Right.
Kirk was a very national public figure. So it's like,
Mhm.
are
Right.
you going to get a better jury by changing it? And maybe that's one thing the prosecution could say is, hey, it don't matter if you change it. You can change it all you
Okay.
want. You're still going to end up with a jury that knows about this at some level. But I'm sure, they could still find a good jury, likely where they are. And definitely if they change too.
Okay.
I love it. I love it.
Yep. So
Nice work.
the the sanctions. What are the odds that the judge is going to actually give sanctions from this particular violation that occurred last week?
On the
What
media
what are the
member,
chances on it? Yeah.
it's so I would say this. It's probably going to come down to how was the standing order worded. Is there any reason? I mean, it's likely the court's going to say to that media member, order to show cause related to why we should not impose sanctions for your violation of the order. And then that
Hmm.
media member is going to be obligated to provide a response. And
Okay.
is the response a sufficient one? Is it? Can he say, hey, the language wasn't clear about this point? That could be
Hmm.
one ground. If the judge finds that persuasive, he may just amend the standing order to make it more clear. May not change it and just impose like a very
Hmm.
strongly worded order. Maybe it's a lower sanction than what I said. So there's a lot of options on the table, and then the likelihood of it being imposed. If this was a first time offense, I think that can
Hmm.
definitely weigh into the situation. And so
Okay.
if the judge just makes it clear, like, hey, I know this happened one time, and this first guy said he didn't understand the order, he or she didn't understand it. But if
Right.
this happens again, I don't care what you say, about it. I'm going to impose sanctions.
Oh yeah, absolutely. And I think that's exactly what should happen. Especially if it would be challenging to take it anywhere else and you still have all of this information being peddled out from, these huge content creators, Candace, where it's, the information is being heard, throughout the state. And of course, picking a jury at this point is going to be so difficult. In the process to jury selection, I've kind of gone over that. It's not as straightforward as people think. So they want to be able to select the best jurors and then have their alternatives on the side. And
What
if
would you ask the potential jurors?
I mean, I would ask, of course, what there is exposure information out about this case. It's being nationally televised. Everything that's going on with it is being scrutinized. But I would ask basic questions on um th- their
Have you heard of
understanding
this
of
case?
being able to evidence or anything. I have I watched the hearing
Well,
regarding
I would ask. No, I would
these.
ask the juror that. I would say, have you
Oh,
heard of
have
this
you?
case before? Yeah.
Oh yeah, have you heard this case? Your understanding of the defendant. Um, what do you understand how to gather evidence? Do you understand what the evidence has been gathered? Do you listen to what are you listening out to social media? I mean, or what is your influence? How easily are you swayed or influenced by social media
Yeah.
or by certain individuals in social media? Because that kind of gets to the heart of are you selecting a jury that can be impartial and not be influenced by the things that are being said, especially by these high profile figures like Candace. Whether people are subscribed to her or not, people are still listening, and that is problematic. And
I
so
would
if if there's a chance that they come in there and they might be ones where they firmly believe what she's saying, you got to ask the questions to kind of weed them out. So it would have to come down to that. That to me would be the biggest hurdle. If you're being influenced heavily by social media and certain social media presence and information that they're putting out, if you're swayed on this, it's going to make it hard for you to be able to see this, impartially. So go ahead. I'm sorry. I didn't mean to cut you off.
Yeah, no, I mean, I would probably ask, similar questions as that. In
Hmm.
addition, probably like,
Hmm.
this case deals with some serious facts. We have an allegations
Right.
related to murder. Like, would you be
Right.
able to emotionally tolerate sitting through a trial like this and be able to like come, to a verdict on that? Like, is that something you feel like you could emotionally withstand? Because I'm sure
Right.
some people, once they have like these weighty allegations, who's to say, somebody in their family didn't experience like a murder of their
Right.
family member or something, and like they just couldn't decide, or that it would
Hmm.
remind them too much of something in their own past. And so like I would
Hmm.
probably be asking some of those questions too, or like how political are they?
Yep.
Do you find yourself to be a very political person? Do you know who this is?
Hmm.
Regardless of a person's politics, could you see them as a victim of something like that, whatever speech they may have said? And so those are going to be really important questions. And like, I'm sure, I mean, a lot of people are very opinionated. But
Yep.
maybe you could find certain people that like, they don't follow politics so much, or like, oh, they're
Right.
fine with, and so like I would be trying to locate those in some sense. But if I were
Right.
maybe the defendant's attorneys, maybe the prosecution and defendants just have different, like, who they want to go after as potential jurors too.
Right. And in both, of course, both sides have the opportunity to ask questions to help determine, the jury selection. I feel like Candace, and it's just my opinion, is saying a lot of things that could end up helping the defense. Especially if, there's been so much doubt cast on the investigation overall, and especially coming from someone who's not very well versed on the law or on how a crime scene is processed or evidence gathering. She's not versed on any of those aspects, but yet her ability to sit and paint these narratives, and people are going with what they're feeling, like you said, the emotion, the connection that is being swayed with that. I think would be the best way to weed them out, that emotional connection. If they have someone that they know they have they've lost in that similar fashion, you want to kind of say, okay, well, you don't want to be emotionally connected. You don't want to be, because you're being emotionally connected to things that are being said from someone that is invoking all of this doubt. So you want to be more factually based, and you want to be able to have a clear head so that you can make a decision that's impartial and neutral based on the finding of fact and evidence and what the law says. Um, and get down to that. I think they're gonna have a hard time, really, if she continues to go at this rate. They're gonna have a harder time trying to really weed out people um that would not serve well on a jury. That's just my personal opinion. I think it's gonna be a little bit more difficult as time passed by. So you let me know your thoughts on that. You think that is
I'm
I
not
don't know
so
if you
sure it
listen
would
to
be
all her
that.
shows, but
Yeah, and that's the key question. I don't know how, like, if we suddenly got 16, 20 jurors sitting in front of us, random people
Mhm.
selected, like, how many of them have heard of Charlie Kirk? I wouldn't say 100% have ever even heard his name. Like, they might not even know
Right.
who this individual is. And so, like, those would be people automatically. It's like, all right, well, they don't know. Oh, this person was really following the case. Well, strike them. They're out of here. Like, because
Mhm.
inevitably, like, yeah, if a person's too biased, it just kind of negates their own independence, and they can't really consider the case independently.
Right. So let's say, they're learning about him through watching someone like Candace Owens. You know, maybe that's how they're, getting information about who he is and all those things, but they're getting it directly from that one source. So would it be appropriate to ask,
You
hey,
could ask them.
are
You could
you
say,
do
do
you
you
watch Candace
watch?
Owens?
Yeah, I would say, do you watch podcasts like on YouTube? And if
Right.
so, what do you watch? And like, if they say something that is Candace Owens, or if somebody related to Candace Owens, like in
Right.
that ecosystem, I could then
Uh-huh.
say, oh, well, strike that person, if you want to strike
Right.
them.
Oh, okay, cool. Because that would be my if I had to ask the question flat out, do any of you watch Candace Owens? And it just whoever their hands up, you gotta go.
Yeah, yeah,
Because
that's a good way to
I
do it.
would I just would not want that on the jury, because I just don't see how anyone that's listening to her regarding this matter is remotely able to be impartial. It's just complete biased. So yeah, you gotta go. But
Yeah, and
go ahead, go ahead.
I was going to say, a lot of attorneys, when you're at trials, like, they're just
Mhm.
constantly, I mean, I was once a juror actually after I got licensed, interestingly enough, and I hadn't done a
Mhm.
trial myself at that point. So I truly felt like a juror, and I'm listening to the attorneys, but I'm a trained
Mhm.
attorney. So I'm like listening to them to present their points. And I just remember my own impression was, every time they were up there, these attorneys were asking me, all right, let's just hear
Mhm.
all the evidence. Let's be impartial. And they're like constantly reminding you of it, to the point, like, it's almost like you
Mhm.
hear it every day, every minute, every hour. It's like you do kind of think into that. And
Right.
then ultimately, like, it's difficult to trust any, like, the jury system is like, it's what our system is. But, when you're dealing with actual human beings, inevitably people
Mhm.
are going to see them as biased. And, we've always heard, in the past of, people not believing certain juries or jurors were
Mhm.
fair and they're deciding. So I think you might not ever escape those allegations. That just might be,
Mhm.
you kind of take the bad with the good, I suppose, in some sense. And that's going to be one way to attack it. But what other
Right.
system do you have, I guess?
Right. And this is a question from Truth. Can they check potential jurors' social media? Are they able
Yes.
to even? Okay.
But you
Oh,
cannot notify a juror that you checked it generally. So, like, how, like, if
okay.
you get on LinkedIn and you go to a
Mhm.
person's profile, it'll notify them that this person checked their profile.
Okay.
Yeah,
Yes.
if it notifies that potential juror, like, Nick Brooks looked at your LinkedIn and they know that, that would actually
Oh
be
boy.
improper juror contact. I had to go to a recent legal event and they were telling us about that.
Wow. So they would be able to check their social media if it's. I mean, well, does Instagram or Twitter X, does it notify you if someone has checked out your page?
I don't believe so. I believe those
Okay.
platforms don't, but LinkedIn
Okay.
was actually the specific case I was dealing with. And when you visit a profile on LinkedIn, it'll notify that person that somebody's visited their profile. So be
Okay.
wary of that.
Okay. So that would be a good way to weed them out without necessarily having to put them on, on the forefront and asking. I mean, I would simply ask, do you listen to Candace Owens? That would probably take away a lot of that biasness, but they can also go in and check just social media. That would be a great way to also determine what they're looking at, and if they're heavy on social media, they're constantly posting, and responding or engaging in conversations. That gives you an idea of what that person, is thinking, and then of course that gives you an idea of whether or not they will be a good fit to be a juror in this matter.
Yeah.
Um, Susie Q, shout out to you, honey. How you doing? She's asking, can Brigitte Macron be forced to prove she is a woman through testing? I
Yeah, it's
think
going
did
to
we cover that earlier?
a little bit. Yeah. And
Yeah,
just
go
kind
ahead.
of a quick,
Okay.
I mean, hey, it's going to come down Delaware state procedures and she's going to have
Hmm.
to show good cause for any type of physical examination. And I question if, good cause is going to be sufficient, but, she'll have to bring a motion and show that. And the judge will order it, after the opposition too is filed.
Yeah, I just personally, I've said this previously. I don't think the judge is going to order her to get tested, but I mean, and mainly because the attorneys are going to object to that heavily. And what would be the legal premise to this? Like, if even if you have court rules to say, "Hey, I'm claiming she's born one gender over the other," that was no intent on doing. There was no reason to even do that. It's not like you're, trying to protect the public from anything. So it was just more salaciousness to begin with. So if you say I file a motion for her to be tested, and her the Macron's attorney is like, well, why should they have to be tested on something that she theorized, and she has no evidence to prove that she was born a man to begin with? Um, that
Or
was
she has
the reason why.
alternative discovery methods to prove her point. Like, if
Hmm.
she gets documentation, medical evidence, for example, through documentation that shows that
Hmm.
her claims are, false. I mean, I
Hmm.
saw some commenters say, well, oh, medical documents are easily falsifiable. Well, you don't turn in documents to the court that are
Court.
false. You'll violate the law in doing that and potentially land
Right.
in jail and lose your license and everything like that. So I
Right.
don't think anybody's going to be submitting false evidence, under penalty of
Hmm.
perjury in this case.
Right.
Um, and so, yeah, if she moves for a physical examination or testing of some sort, and
Hmm.
it's not really warranted after all of the other evidence available,
Hmm.
I don't think it'd be tough to see her getting that. But there's no guarantees in
Right.
law generally.
Yeah. Okay. And then of course, they have an order that was posted up on December 12th. So her attorneys, Candace's attorneys, were granted an order for a word limit and deadline for reply in support of the motion. They increased it by 7,500 words, and that is due January 6th of next year. So, I mean, they're doing this deliberately. They're trying to delay this as much as possible. What are your thoughts on that? And I could pull up the actual docket so we can see it in real time, because it's like, why did it keep stalling on this?
Yeah, no, I mean, generally, whenever you bring motions or oppositions or replies, you're required
Hmm.
to only have a certain maximum word limit and pagination limit. So how many pages you get. And so
Hmm.
you can motion to extend the word, or, make larger the word limit or more pages. It's just, you generally have to show good cause for why you need that. I suppose that she brought that motion, or would they stipulate to it here? Or?
Yeah, it's a stipulation.
Yeah, since they stipulated to it, she didn't even have to move for it. So the
Move
attorneys
for it.
agreed, all
Yeah.
right, go ahead and file your
Yeah.
expanded word limit motion. So she'll file that. And
Hmm.
I've never really needed to bring like my word limit up. You just kind of got to state
Right.
your issues more concisely. Like if you find yourself trying to expand words, it generally means you're not really getting to the issue, And so,
Right.
and maybe she wants,
So,
it could be a distraction tactic. We never know.
I think so. I think that, because this is the second request for an increase in word limit. Even if they're saying, well, the FAC, the First Amendment complaint, is well over 220 pages, so our response needs to be able to address what's being stated in the amended complaints, or whatever motions they're bringing forth. It's just, they know they're going to need these additional words. They know that court rules won't allow so many pages of terms. Why wait to the last minute to file this? Or, they stipulated it, but, the Macron's attorney filed an answering brief on December 3rd. And it took them to the 11th to get a stipulation done where I guess they agreed to say, okay, well, maybe it's because the holidays are coming up. I don't know. It just seems like they are stalling. This is the second time they've asked for an extension, or they want to increase word limit just to still say the same thing. It's like she's going out of her way to avoid this hearing. So
Yeah. I
I,
mean,
I just think it's a ploy. Yeah.
you're generally permitted to, obviously, once you bring a motion, the other side has a right to file an opposition brief or an answering brief, as they
Right.
term it here. So that's what they did.
Right.
And then after the answering or opposition brief is filed, the moving
Right.
party then gets to reply to that. And then
Right.
generally there's no reply to the reply, although sometimes it can happen, and depending on the circumstance. But
Hmm.
so when it comes to the reply, you're limited though to like a lot of what was stated in the opposition that you're trying to like poke holes in. So you can't just start referencing things external to the opposition or the moving papers themselves.
Okay. Okay. And I mean, it's just, this is why I'm like, why don't they just have a hearing on the motion? That way they can present their arguments. And, as far as adding extra words in, what are those extra words going to even address that they can't address directly, you know, in a response or a reply? I mean, they're trying to get the matter dismissed. So if it's being dismissed based on libel tourism, you're basically, stating your claim again, and then maybe trying to object to any further or new additional accusations being brought forth, or any claims being brought forth. But if you're objected to that, then you're objected to that. But if you want to go, if just go to court. That to me, that's my whole thing. Why not just go to court? Why not just ask the court for a hearing on the motion to have this heard, and then they can bring forth the legal arguments and do it that way? Why keep asking for additional words in writing? That's what I'm
So
confused about.
whenever you bring motions, you're generally required to submit moving papers. So you do have to submit the actual written documents themselves, which set forth your theory, because that
Yeah.
just allows the court to read what you have, instead of like, because when you're dealing with somebody orally, sometimes it can be all over the place, versus if you
Right.
have to write it down, we can, all right, this is your position. Now we know it. And so like,
Right.
each side has to submit all of the moving papers properly. And then after the moving papers are submitted, the court can generally, it has the option to have a hearing. They can, hear oral arguments from the parties in support of their moving papers. And so a lot of their oral arguments will have to be limited to what they put in their moving papers. So they can't write these things in their moving papers about A, B, and C, and then in their oral argument talk about D, E, F. They're limited
Right.
to what they wrote down. And so but the oral arguments just to supplement and help the judge further understand anything that, he doesn't or she doesn't already understand from the moving papers, or resolve any questions.
Okay. And there was a question here. All right. So, in my opinion, this is from Greedy Puppy. The issue is not if Brigitte is a man or a woman. The issue is that it had a relationship, or Brigitte had a relationship with a minor and a student. So, when it comes to matters of that nature, what what role is that going to play as far as, Candace trying to use this defense? Well, I didn't report on this because she was born a man. It was more so because because you can't say she's born a man, but then say she was preying on a student at 14, 15 years old, I guess, of some sort in France. That action did not occur in the US. So, I mean, what value is that to a court here in the US to say, well, we're bringing up this issue because we believe that she was, trying to, coach and engage with a student in France while they lived in France.
Yeah, I mean, with respect to the minor and the student allegations, those are serious, improper allegations, and in our own social discourse, we don't really endorse relationships like that. And so I can understand why people have moral and legal issues and objections to any type of relationship like that. But I guess the issue here is we have to focus on what are the allegations as set forth in the litigation. And that relates to defamation and Candace Owens calling Bridget Macron a man rather than a woman, and alleged reputational harm. So that's also an issue. So we are dealing with two issues. It's just the litigation has to concern, it's concerning one, and we do have to properly resolve that particular issue. That doesn't take away from the other issue. It's just, that other issues dealt with differently, whether it's social backlash, elections, or independent lawsuits on those issues. And so that's just how I would frame it, is I understand the inappropriate relationship and things of that for many people. It's just we have to deal with the defamation issue as well. And, you can't just use this issue to distract from this issue. And we don't want to address this issue because that issue exists. It's that's not the way litigation works.
Right. And then also, there's nothing that the U.S. court can do about that, right? If you're trying to bring that forth to say, there should be some sort of punishment or penalty, what penalty would you expect a court in the U.S. to do about a matter that occurred over 30 years ago in France, where they ended up being married? So it's like, what are we supposed to do about that in court?
Yeah, you have to generally, if you're going to be a prosecutor or you're bringing civil cases, usually where you focus on the venue, as we discussed, and where did the acts occur. Here, those alleged acts occurred in France. And so they would properly be adjudicated in France with respect to that inappropriate relationship. The reason the defamation, its venue is here in the United States, is because those alleged defamatory acts occurred within the United States. Yeah. And so that's the nuance on that front.
Yeah, absolutely. So to sum everything up, is a lot of this Candace Owens has done. She's initiated on her own accord. And the additional, defamatory attacks against TPUSA, implicating everyone or inferring that everyone is involved. From whole countries to, the French president to, TPUSA and individuals in TPUSA, Erica Kirk. It goes on and on and on. It's bringing forth a lot of cyber crimes, such as not cyber crimes, but cyber harassment, the bullying, the more defamation, and doxing. So I know I've spoken heavily on that. Doxing is illegal. It's illegal. When she puts up people's photos demanding to know who they are or to get information, I could say she's liable for that. But what are your thoughts on that? if they decided to pursue lawsuits. Yeah, hey, you put my photo up on your channel, and it's the guy in a green hoodie, and now this kid is getting, backlash and retaliation. All the kids that she's posted up photos of that, because they were wearing maroon shirts, now they're being subjected to, this campaign of harassment and bullying and defamation. You know, what are the chances that they're going to go and try to pursue something in court against her on that?
Yeah,
What are
it's
your
a good
thoughts?
yeah, it's a good question. I'm not sure. I think they'd have to evaluate, like, do they want to pay an attorney's fee to pursue something related to
Hmm.
harassment? Do they feel like they have a strong enough case? A lot of some of the things we've discussed is like you have to identify like real identifiable people, and like how close do you
Hmm.
come to actually identifying them versus maybe what you said actually technically it could mean this person, it could mean that person. And so like there's going to be like legal defenses, I'm sure, that if
Hmm.
Candace Owens isn't naming people exactly by certain names, like, oh, this
Hmm.
particular staff member was involved in this particular way, I think she might have
Hmm.
some wiggle room, at least to potentially, avoid a civil litigation suit, only because
Hmm.
maybe the plaintiff just feels like, man, this is going to be really tough to prove and really expensive to prove too,
Okay.
if you bring it. And then also, um, some of those like TPUSA and Erica Kirk, like they're public, figures at that sense. So it's like if their defamation suit is not successful, and then
Hmm.
let's say Candace Owens herself, brings that anti-slap suit against it and says, I'm trying to participate in matters of public opinion and public concern and
Hmm.
stuff. Then, Erica Kirk's attorneys could potentially face, and Erica Kirk herself could face like attorney's fees if they lose that anti-slap motion. So or even the
Okay.
TPUSA or others. So it's just like you have to
Hmm.
calculate like how strong is our case. If we lose, we might face attorney's fees because we're dealing with matters of public opinion. And so it's a tough situation to be in for the parties.
Yeah, absolutely. There's an example. And I think this will be my last question, and any questions from the audience as well. So we don't have Nick sitting here all day, 6 hours, because I can go 6 hours. But I want to ask about Tim Pool. He's another content creator in particular where in that situation, Candace Owens brings him up, because he gave his criticism of her. Candace, in her mind, in her alternate reality, doesn't believe that people have the right to free speech when it comes to criticizing her. But when he criticized her, of course, she, said something back. And then what resulted from that a couple days later, ironically, and I can say that ironically, his house was shot at. And so there's a lot of questions being, thrown out there as to whether or not that was done simply because Candace Owens brought him up. Um, if he decided to file a lawsuit, and he says, well, hey, this incident occurred 2 days after I said something about Candace Owens, and she responded back to me and she called me a bunch of names and said all these things, but now I had to deal with someone shooting at my house. What do you think, or what are your thoughts on that if he decided to sue
Yeah.
and say she's involved?
So the only
Hypothetically.
way that he could possibly recover in a situation like that against Candace is he would have to
Hmm.
show that there's like an agency relationship between the shooter and Candace Owens, and that Candace Owens
Hmm.
directed that, because Candace Owens isn't responsible for the conduct of others, too. She can say certain things, and if people interpret that a certain way and they act, in a criminal way after that based on what they heard,
Hmm.
unless it's like you can't call for violence and stuff and direct it at people. That would be a violation of the First Amendment as well. Like that's not protected by the First Amendment. So,
Oh, okay.
yeah, it's just, if what she's saying just makes people kind of hateful and they're willing to act in a criminal way of hate, you got to hold accountable the individuals that actually committed the act, not just Candace
Right.
Owens for stating things.
Right.
It's just, I guess, with Tim Pool, I don't know if you saw my post. So Tim Pool is
I haven't
definitely
seen.
yeah, Tim Pool, like what's interesting was when I was in law school at Rutgers, there was this
Hmm.
judge that I knew who, I saw her speak once or twice. I never really had a relationship with her. Some of my classmates said that
Hmm.
they really liked working with her and stuff. But
Hmm.
she had a couple of controversial cases, because when you're a federal court judge, like some of the cases that come across your desk are cases you're going to see in the news and stuff. So,
Absolutely.
she had a case involving men's rights attorney here, or there was a men's rights attorney in California who he went crazy, and he drove all the way to New Jersey because he wasn't doing well in the case that she had or he had with her, and he targeted her and her family and shot and killed her son, and then shot her husband, and then like he survived. And then she like went on the news and gave like, she was almost like, we need to be more protected as federal judges because our public information sometimes out there, and crazy people look it up and target us. And so she was trying to push for litigation in that aspect to protect, herself and try to use her example as like a way to do that. And I felt bad for her. But then like literally within like 24 to 48 hours, Tim Pool picked up on the fact that she was overhearing something to do with an Epstein case. And so he correlated that man who had another case with the men's rights stuff with Epstein. He started talking about, was she targeted because of the Epstein stuff? And it was like, when you see, like, 'cause I was actually classmates with her niece. And her niece was a very, nice young woman. And I never really had much of a friendly relationship with her. I kind of saw her around the building. And like, I don't know, when you kind of see people like that and you interact with them, and then like, some tragic events like that happen and people start piling on, it just kind of teaches you that like, whenever there's gaps in information, people are going to fill them. And all it took was seeing a judge targeted, seeing a case on her docket that so happened to be, Epstein related in some sense. And that was enough for people to connect the dots on that. But it was really a matter of this one attorney just didn't like how she was dealing with the case. And, she refused to hear like an oral argument from him and stuff like that, because she was going to decide the motion on the papers. And like, I don't know, that attorney, he had like some Russian wife who left him, and then he went crazy as a result and blamed the court system. And, it's
oh my goodness,
psychotic.
You can make this up.
Yeah.
Wow. So, that, I'm sorry, I'm let you finish.
No, I was just going to say too, like that same attorney, he kind of, offed himself after that, after he did those crimes. Yeah. So he never faced accountability for doing that. Actually, he disguised himself as a FedEx driver to approach the home too. And so it was a terrible situation, but he had brought some cases where it was like he was challenging local bars under gender rules, because you can't gender discriminate, but he would challenge bars for having like ladies' nights. And he would say that's a form of gender discrimination. So he had this like personal kind of vendetta, you know what I mean, to get after like certain women, I think, that he thought affected his lives very negatively, whether it was his wife or the judge, dealing with this case. So
wow, that is, and you know what, and that leads to Candace making this statement, which is it was so disgusting. She stated in the show, because she has an issue with Ukrainians, I guess. Who knows what the background is on that? But she actually stated that if anyone lives in certain areas in the state of Tennessee, that if they believe that these people are Ukrainians, that they are to contact the local authorities. And that was it. And it was like, okay, but based on what crime? You have to be committing a crime. You're directing people to contact the local authorities. If you believe that these people if they look like they're Ukrainian, or how would they know that? Who knows? But if they're Ukrainians, contact the local authorities, because I don't believe that they should be here. You're telling people to contact. That is a crime, to file false police reports. Here's an example of where she's directing people to do things that go against the law. And then you're saying, contact the local authorities and say, well, here's some Ukrainians here. Ukrainians here in the state of Tennessee. But what crime are they committing? You're literally putting people out there, in danger. Like, you're endangering people's lives and their safety, disrupting their quality of life, the right to live in peace. When she's doing these things, it's kind of hard to say she's not. And she said other things in the past to where, people are getting this incitement to want to, send death threats. 2 men are in jail because they were influenced by Candace Owens. And they sent online death threats to Jewish conservatives that she targeted. So, when you have those examples of her having that influence, where people are incited to violence, or she's directing them to contact the authorities because they might possibly be Ukrainians. How would they prove that? Who knows? But when you have those situations lined up, wouldn't that be valuable? If someone decided to file a lawsuit to say, here are some other examples where she's doing this. This is a pattern of behavior. Harassment is, showing a repeated pattern of behavior. Wouldn't that hold up, as at least something viable if someone like Tim Pool, for example, decided to file a lawsuit after having his home shot at?
I would
Yeah,
say
just your thoughts on
no.
it.
I would say no,
Okay.
only because it's difficult
Okay.
to prove causation. You have to
Okay.
show that Candace's acts caused
Okay.
these, this result. And I think
Okay.
what her defense would be is my acts didn't cause that result. This
Hmm.
person did that themselves, and they're their own person. I'm my own person, and that would kind
Okay.
of be the framing of it. So it would be ultimately a causation analysis on who caused the negative result that occurred. And I think she would have strong arguments in that, because generally, it's
Hmm.
different than directing a mob like, hey, go attack this person because they did this, versus like, if you're just like, I don't like X group because I find them
Okay.
despicable for Y reason. If that just gins up hate,
Hmm.
what I would recommend is you just have different voices that can kind of reason with people that become hateful. But yeah, she
Hmm.
wouldn't be held accountable just for hateful acts of others. Um, you know,
Okay. Or what about her statement saying to contact the authorities if you see Ukrainians in Tennessee? I mean, what these poor people, if they got the authorities calling them, you're talking about, quite possibly them having to interact with police for no reason. I mean, what would be her liability in that? She's
yeah,
directly saying to do that.
yeah. So it's definitely, it's not directing violence. I'll say if you're just directing people to call the police, she might be
Mhm.
legally, incorrect on, like the standards to call. It's tough. I've never heard of a case like that, truthfully, like somebody getting,
Yeah.
like doing that. So I'd have to do some research on that. My
Okay.
instinct though is like, ultimately you're generally responsible for your own acts. But I mean, here we're dealing with like, if the police suddenly got a bunch of like administrative calls that
Mhm.
they've got to sort through, like what's the
Mhm.
quantity? Is it only like one or two calls as a result of this, or is it
Mhm.
10,000? So it's like, I think you would have to take into to that. And then, maybe
Mhm.
it's tough. I'd have to consider that more.
Okay. This is what I love about you, Nick. You give us the matter of the fact, direct answers and responses that we all need to know, and you're very impartial, and I appreciate that. If you guys have any questions that I did not get to here, let's see here. The check a speech. Okay, I'm sorry, that's not for me. If you have any questions that you would like for me to send over to Nick Brooks, please make sure you email me at ladyluckclubllc@yahoo.com. Make sure you go check out his channel. And he does look at his comments. So yay. You guys can also ask questions directly under his videos. But this has been fantastic. And I enjoyed Jay Wick coming up. He had to step out, you guys. So he dropped off. But I appreciate you so much for coming in. I have definitely enjoyed this. They say you are the bomb, honey.
Hey, thanks a lot.
He's well dressed, well spoken, but I just love your, matter of fact, direct responses and information. And like I said, the impartiality to me is the best. It just ensures people that we want to put out the facts here in the Lady Luck Club, and we want, I can give my personal opinions of Candace all day, and I will this evening. But when it comes to the facts, and especially dealing with legal matters, you want to have someone that is knowledgeable of the law and that's going to litigate matters in the right way based on court rules and the evidence, and stick to the facts. And that is exactly what Nick Brooks has done in this, um, 2 hours and 43 minutes of time we've had with him. So I want to thank you for your time. And you are always welcome to come back. Maybe we can do a reaction to one of Candace's shows. If you can, I can't watch it by myself. I have to have the Luxes with me. So if you're able to do that at some point, next week is Christmas, but whenever you have free time, you want to do a reaction with me, I would love for that, for you to join us here. That would be a ton of fun. So
Yeah.
thank you so much, Nick. You have any other, thoughts, comments, questions, anything you want to share with us before we end?
Yeah, I guess the only thing I would say is thanks for having me. I've definitely followed your show, and like
Yeah.
when I first came across your channel, featuring my videos, I was
Uh-huh.
laughing because that was the one I said, "Well, bring it on, sweetheart," and you were like, "Oh, but game on, Heffa," and I was laughing when I heard that. I was like, "Man, that was one of the best YouTube videos I've heard in a while." Um,
Oh, thank you.
yeah, but other than that, no, I mean, I just appreciate like a lot of the commentary. I think it's important that like people publicly dialogue about these issues. I think you and
Exactly.
Jay Witt do a great job, like, dialoguing about them in good faith. You try to,
Mhm.
keep the evidentiary standards high, and you do good
Right.
faith questioning, and like
Mhm.
ultimately a lot of truth lies in the adversarial process. So like, the different points
Right.
going back and forth, and like trying to get, expert opinion or get knowledge of the different documents. Like, I think that's important. Your followers definitely love it. And, I
Yes.
appreciate you supporting my channel, and like your followers definitely support it as well. So, I'm
Yeah.
grateful for that.
Thank you so much. I appreciate that as a compliment. And I'm going to be doing a marathon at I think it's set up for 5 or 6. I think I can't even remember the time I have it set up. I think it's for 6 p.m. Is it 6 p.m. this afternoon? I'm going to be doing a marathon on her 3 episodes. So that's going to be fun. And then it's 5 p.m. Eastern Standard Time. So within the next hour and a half, I will be doing all 3 of her most recent episodes, plus taking a look at her interview with Piers Morgan. I don't know if you've seen that, but I've seen parts of it, and oh my goodness, it's just, he's asking direct questions. I mean, he's been doing this for a long time. Piers Morgan, I think, asked questions that needed to be asked about, especially her, accusations and inference of TPUSA being involved in the cover up of or associated or affiliated with the murder of Charlie Kirk. So, you know, she had a hard time, of course, answering it. And what she does is overtalk. She just overtalks. She just goes on and on, and she doesn't provide anything of substance. And is that it's not even answering questions. It's not even debate. It's just her rambling for the sake of rambling, and it is something else. So if you're able to tune in, join us. And if you want to come up during the marathon at any point in time and give any thoughts or insight, please do so. But I
Okay.
do appreciate you tuning in. You guys, thank Nick Brooks for coming in. Make sure you guys go check out his YouTube, and I'm going to end it out. So I'll drop you, but you let me know if you have any other questions or any availability you have to do a joint reaction. That would be a lot of fun. And I think Jay Witt is looking forward to speaking with you as well. And I'll be
Wonderful.
tuning in with
All
that.
right. Well, hey, no, have a good day. It was good to speak with you.
You too. Thank you so much. Have a good one.
Bye.
All right. Bye bye. Y'all, Nick Brooks, I am so happy. Oh, thank you all so much for tuning in. That was so much fun. I've been looking forward to that. I hate that I had technical issues, but if you guys are just coming in, please make sure you check out the replay. We addressed a lot of information, answered a lot of your questions, and he did exactly what I am so glad he did, and I was hoping that he would do, and this to give direct information, direct facts. That way, because Candace, I know you listen to Heifer. You can't say, "Oh, well, she told him to say this and that." Nope. Even when he gave a response that was, well, no, maybe she would now be able to prove this, prove that. We give the facts here, and we want it to be as neutral and just as direct and straightforward. And I appreciate all of you all so much for tuning in. Let's get Nicholas YouTube channel link dropped once again. How you doing, Billy? And then I'm gonna get to some supers. I appreciate you guys so much. We're gonna be back at 5 p.m. for all of her episodes. We gotta do 3. So you guys need to come prepared with lots of Kool-Aid and popcorn, grape soda, get your gummy worms, have a meal, bowl of ice cream, something. And we're gonna have at least 3 hours dedicated to that because I want to cover her last 3 episodes she's done on Wednesday, Thursday, and on yesterday. And of course, the Piers Morgan interview, along with a couple of other videos that you guys sent me that just, we need to watch. But I enjoyed this. You guys, this is what it's all about. Being able to ask questions and get real information that can also be researched. The aspects of, the law and what from state law to federal law, um, with permit, court rules. Those things are matter of facts that can be researched online, that you can read about. And that's what I, appreciate the most. And I am so excited for Nick Brooks and his success with his channel, as well as the success of the Lady Luck Club. If you are not subscribed, subscribe. We're almost at 30,000 supporters, and I want to see that number hit hopefully by tomorrow. I mean, when I say we're close, we're so close. I'm less than 21, 31 people away. I am 31 subs away from 30,000. So let's make that happen, you guys. Hit that subscribe button. And if you want to become a member of the LLC, consider becoming a member. I appreciate all of the support from you all. I'm going to get to the supers here. And make sure you guys check out from the beginning. We discussed the Macron lawsuit. We talked about the Tyler Robinson ordeal, and of course the standing order with the decorum. Nick said flat out, I would have had them sanctioned. If you're going to have media in the courtroom, they're going to have to follow the standing order. He would have sought sanctions because it could create another level of bias towards the case. You're giving the defense more viable arguments for an appeal. All these things simply because someone felt that, well, the public needs to know that. No, we don't. It's called doing things in decency and in order. We have laws for that. We have court rules for that. And standing orders are as good as law. And so follow the order. It's that simple. And this media group, it's a conglomerate of different medias that have come together and were given permission to record the murder trial and be in the courtroom. They need to handle that responsibly, because listening to all these, clowns out here that didn't go to law school tell you, well, we have the right to know everything. No, you don't. But they don't have anything to do with the hearings either. They're not attorneys. They don't know the law. They don't care about the law. Candace thinks she's above the rule of law. They don't care about court rules. They don't care about, procedure. They don't care about any of that. And when you're invoking more chaos and confusion than clarification, facts, and evidence, these people that are going in and recording as a part of that media group, they need to think about that. They need to think about the fact you could be sanctioned. So, it's a deterrent. It keeps people from doing it again. Let's deter the horrible bad behavior. Let's get off these high horses and stop thinking that, someone owes you something. That's not how it works. And so we want the bad guy off the street. We want him to get a hearing so that if he is indicted and found guilty, it makes it harder for him to come back and try to appeal it, because members of the press were just recording things that shouldn't have been recorded, and it was streamed to, the public. It's unnecessary. Let the matter proceed through the court the right way. And then once it's done, whatever information the court is willing to release to the public will be released. I'm sure there's going to be a demand for it, but it's all about timing. So I appreciate you guys. Let's get the supers in from Jay Witt. Thank you for the $10 super. Y'all said he would give me a $50 super once we hit 50,000 subs. I'm looking forward to that. So make sure you guys are subscribing. Share the content. Subscribe. Tell everybody about it. Your friends, your cousins. Holidays is coming up. Say, hey, you guys, make sure you go on YouTube and check out the Lady Luck Club. She's funny. And we enjoy her content. And I always want to, bring forth facts and the evidence here. We're going to be going over another lawsuit too. Shout out to those who were sending me emails. You guys, just let me know if you want me to. I know S-Files doesn't mind. For all the information you guys sent to me, I do verify and vet. So if I move slowly on something you've sent me, it's because I have to verify this information and corroborate it with something in my research, because that's the proper way to do it. But there is a lawsuit that was sent to me. Candace, we're going over that lawsuit, girl. Dealing with some sort of a coin, like Bitcoin, but it was a pump and dump scheme, which is fun for me. I love those. So we're going to be going over that lawsuit at 5 in our marathon. I can't wait. So let's get these supers in so you guys can get off and go eat some food and then come back at 5 p.m. And then, of course, let's see. what's the super? I was trying to pin up questions as well. Heather Rose, thank you so much for the 4.99 super. I appreciate it. A lot of these questions that were asked, Nick did address and answer the questions. Care Bear sent a 4.99 super. Thank you so much. Heather Rose sent another 4.99 super. I hope the Macrones press for a jury trial. There is a jury demand, so they will have a jury trial if it proceeds to a trial. There is a jury demand, and there will be a jury trial. I just want to be one of those press members so I can record. I don't know, or just at least be able to, yeah, I'd be able to record it and then just kind of share the information or live stream it out. I would have to get permission from the chief judge of that court. So I'll work on a request to the court and see if I can get permission to record the hearing virtually at the least bit. Start there. So and see how it goes. Yay. Thank you, Wyoming Gas. Shout out to my mods, you all. Thank all the mods as well for holding it down in the chat, both in the standard broad as well as the vertical broad streams. I appreciate you guys, the broadcast. Thank you so much for holding it down and for being on hands on deck. Jay Witt is also a mod here too, so I appreciate him coming in and helping to mod as well. Wyoming Gas did the $10 super. This seems like a public perception case. The Macrones should just produce a statement from her doctor and a picture of her and her brother together as adults or appear together in public. Yeah. And I think they have several photos that they've submitted over to Candace where they were trying to get her to correct the record. And she just kind of dismissed it like she does anything else. And so now it's going to come down to it being admitted as evidence in the case. And it's going to be through testimony, which is also evidence. Candace, you got to come, girl. She's going to lose. She's going to lose. But, if they bring in scientific evidence to support that, that is going to be sufficient to prove that she was indeed born a woman. It's just going to, shatter anything as far as the defamatory statements made. Candace did purport that to be a fact, and that's what messed her up. She can't say, well, that was my opinion. No, she actually, out of her mouth, said it is a fact that Brigitte Macron was born a man. She said that. That's exactly what she said in an episode a few times. So it's in videos. So she can't go to court and saying, well, Your Honor, I was just giving my opinion and da. No, she said it is a fact. And once she said that, I keep telling you, heifer, that's where you messed up. You messed up when you said it is a fact. So purporting something that you have no evidence to prove to be a fact is where now you've gone into the realm of being defamatory. And then to be malicious and have this reckless disregard for the truth after they sent you all this stuff and you still want to ignore it. You're going to lose. Now you're trying to insinuate that they're involved in somebody's murder in a civilian in a country they don't even reside in. It's insane. So thank you so much, Wyoming Gal. I appreciate that. Let's see here. MT, thank you for the 199 super. Our Faye Facts first stoic lawyer is a guest. Nick Brooks is so adorable. He's so sweet. But he has a very candid way of answering questions. And if he doesn't know, he said, I'll have to look into that. I'll have to research that. It's something else that I can appreciate. If you don't know, take time, research, and read. And of course, you expect good attorneys to be able to do that. And I appreciate him and his candid responses. So let's see here. Let's get to Heather Rose, another 4.99 super. Thank you so much for that. Candace repeatedly says things like, I know for a fact when stating her claims. Yes. And for her flat out to say it is a fact. There's no other way to draw a conclusion when you're saying it is a fact. There's nothing else anyone can get out of that other than them being under the belief after you stated that and you delivering that, saying that she said this is a fact. It is a fact. There's no confusion in that. So the average person would say she stated this as a fact. Candace. And she runs off when she's mad. Like you have no control, you're no poise, no tact, no nothing. Even when I get frustrated, I still don't sit here and say it is a fact and blah blah blah, and then I can't prove it. It's not how that works, Candace. Go to court, girl. All right, so let's see here. I want to make sure I get. I want to thank you all so much. Now I think this super was for Jay Witt podcast. MT, yours was okay. Yours was there for. Oh God, why didn't I notice this at the top? Okay, so this MT and J, Captain Jax is for Jay Witt, but I'm able to see them all because my live stream is the host live stream, and you have some YouTube channel link for Nick Brooks, so make sure you guys go check him out. That's a new member, I think, for Jay Witt. Thank you so much, Captain Jax, for posting up my YouTube channel link over there on Jay Witt's live stream. He's still streaming. Let's see here. Blue Moon sent over a 999 super to Jay Witt. Nick is a legend in the making. Thank you. And then another 999. Cult leader found responsible in the past for violence other committed. Bullying and lying as well. She is a bully and a cult leader. Yeah. In my opinion, Candace is definitely a cult leader. Her cult of personality is extraordinarily dangerous. And because, many of her followers are, all of this is virtual, right? It's all over social media. You can't see most of these people's faces. So you don't know who they really are. And that's what makes it even more dangerous. They go after, they can have 20 profiles and you have no way of knowing. That's what makes them very dangerous. Telling people to call the authorities because you're looking at what might be perceived to be a Ukrainian is absolutely reckless. It's reckless. You're inundating, the local authorities, their phone lines, time, resources. They're going out thinking something has happened. And it's all because some person thinks this person is Ukrainian and they don't belong in the state of Tennessee because Candace Owens said so. The stupidity of it all. It's insane. So, yes, that cult of personality is real. We've gone over that information. Paramount Tactical also covered that with a special guest. I can't remember her name, but they did a great job at it. And we actually reacted to that video. We showed it here in the LOC so that you guys can see that this is why I'm covering, various cult leaders. We talk about Eligio Bishop, also known as Nature Boy and Carbonation. We're focusing on the new series from Hood Horrors with Polite. Those people are connected to cults, or they were cult leaders. And they admitted it. They were cult leaders. So you get this real-time example of these cults. And what we're seeing is this cult of personality uprising, in slow form on social media with Candace Owens. And then for everyone to be perceived the enemy because you give criticism. She doesn't like free speech when it's directed at her. But when she says something stupid, or derogatory or defamatory, oh, she's exercising free speech. That's mentality that you expect from a cult where you can't say anything about their dear leader. How dare you? But then that dear leader gets to say whatever they want to say about everyone else. And then try to curtail, responsibility. Nope. So the Macrons are showing us how it's done. No, man. Thank you so much for the comment, though. I appreciate that. Laura, shout out to my mod. She's also my administrator here in StreamYard. So thank you so much for the $5 super. Thank you, Nick, for coming on. I hope you guys enjoyed this. This was informative. This was the opportunity to ask several questions to a well-informed attorney who is very knowledgeable and educated. Listening to anyone outside of someone who has an understanding of the law, I don't do it. When people are saying we have the right to know everything. Yeah, okay. Name that right. Yeah, name that right. What's going on, Proud Liberal to you? So you guys make sure you tune in at 5. Thank you so much for you guys' support and for checking out Nick Brooks, his channel. We showed a couple videos today that he was able to help us through. You guys make sure you tune in. Within the next hour and 15 good minutes, we will be back. So Thank you so much. Hit the like button on the way out. Subscribe. We're almost there at 30,000. Let's get to that one. And until the next one, Lady Luck Club out. Deuces.